morning all. This application hearing is in the matter of DEC 001-2025 and is being held before His Excellency Justice Michael Black, with the sitting of the hearing taking place in Dubai. The claimant is represented by Altamimi & Company. Lead counsel is Mr. Anthony Petto, KC. The first and second respondents are represented by Horizons & Co. law firm. Lead counsel is Mr. Sean Yates. Thank you.
Thank you. Please do sit down.
Good morning, Your Honour.
Good morning, Mr. Yates, and good morning, Mr. Peter. If I look up there, I can see you to my left. That's why it might look a bit strange.
Thank you, Your Excellency.
Mr. Yates, as I see it, there are four matters to be addressed in really in this order. The adjournment application, first of all, and I say for your benefit that I think different considerations apply to the committal proceedings than apply to the amendment application and the remedy application. Failing adjourning, then I will deal with the amendment application and then the remedy application, and if it's not adjourned, the committal application. That seems to me to be the logical order.
Yes, Your Honour.
Mr. Peter?
The remedy come at the end, really. Thank you for the indication, Your Excellency. I thought that maybe the remedy application might come after the committal, since it's we've got the application to amend and then the committal, but the remedy application, which is a separate order requiring the identification of the source of funds, seems to be separate and maybe something which could go at the end, but I'm in Your Excellency's hands, of course.
Yes.
It
seemed to me to be, well, let's just see the way we go with the adjournment application, first of all, and see where we end up, and then we can decide the appropriate order of matters.
Yes, Your Excellency.
Just again to inform you why I'm not looking up now and looking down is because you've now appeared on the screen in front of me. Okay.
Okay.
Right. So I think it's for you, Mr. Yates, to kick off.
Yes, Your Honour. Thank you. Can I just check that Mr. Britton is online?
I'm told he is.
He is. Very good. Well, Your Honour, that was the first point to indicate that he isn't here, in fact.
Yes, I gathered that.
In relation to the reasons as to why that may be, given that he is here and able to, or remotely, it may be something that Your Honour wishes to address to him directly. Insofar as the multiple applications are concerned, it's correct, as Your Honour has identified, that there's a degree of commingling and codependency here, because to some extent the remedy application and the amendment application touch upon the adjournment application. And so, although I'm not appearing on those other applications, I may stray into that territory.
So just for clarification, you are not here to apply for the adjournment of the remedy or amendment applications, is that right?
We say that if you adjourn...
That's not the issue. I just want to know what you're instructed on.
My instructions are to request the adjournment of those two if there's an adjournment of the committal.
Okay, so you are instructed
Only to that limited extent.
for the adjournment of those applications.
In the event that there is an adjournment of the committal hearing, yes, Your Honour.
Okay.
Well, Your Honour has the history of this case and the advantage over me on that point. So forgive me if what I do is to go back to some of the basics, and I'm happy for Your Honour to say move on, because I know that, or I'd like you to take me to a particular point.
Yes, of course.
But the starting point is, in fact, to take you back to 1066 and the start of the battle. That's 1066 of the bundle.
Oh, that's neat.
So, Your Honour, this is the start, and the original application for committal was filed on the 16th of March, and from the bundle in pages 1067 to 1068, you will see the original format of the particulars of contempt. This was the subject of criticism since then, and you will see that there's effectively homogeneous allegations against 2 different respondents on 5 different provisions from 2 different court orders, and there's no real distinction or separation between them. So the starting point is that this is a non-compliant first effort at the committal application. And the reason why it's non-compliant is evident from page 15402 of the bundle, where Your Honour will find RDC 52.9. 52.9.2 requires that the application notice must set out in full the grounds on which the committal application is made and must identify separately and numerically each alleged act of contempt, including, if known, the date of each of the alleged acts. That is not what we see on pages 1068 and that seems to have been accepted because we then find a second effort at particularising those allegations, which was filed on the 30th of April 2026, and you can see that in the bundle at page 1282. So 1282 is the application notice, and what then followed was some particularised versions with some 32 odd pages setting out the type of details that were in fact required. Now at this stage, Your Honour, they remain a draft. So they are not the contempt allegations that are on record. The only allegations that are on record in final form are the original non-compliant version of the 16th of March.
Yes. Am I right in thinking that the only evidence that has been filed in support was the original second affidavit of Ms. Jubala?
That appeared at, I believe, at the same time, yes.
Yes, okay.
That's at CB 1310. That's the main bundle, 1310. Now, driving over to a slightly different territory, it's notable that these draft particulars of contempt filed on the 30th of April, it was about 5 days after that that Horizons came off the record. So there's only 5, I think it was 6 they came off the record, 8 they notified the court on May.
Mm-hmm.
So there's only 5 working days there, Your Honour, in which to do anything about those very extensive, particularised allegations of breach. There was then a third iteration of the particulars of contempt, and you'll see these in the bundle at 14922. That's the amended draft particulars of contempt. These were filed on the 17th of 2026.
So you said 14922.
14922, Your Honour.
14922, thank you. Yes, there's the 17th of July, aren't there?
Your Honour, and what we have there is a document that was not the subject of an application. It's not something for which permission has been sought. It was served alongside a skeleton argument. It was attached to the claimant's skeleton argument and submitted in that way. So that's a third version of the particulars of contempt.
Yeah, I mean, it's not particularly different, and indeed it withdraws a large section, doesn't it?
Your Honour, it does more than delete. It deletes two of the sections, so from Schedule A, items F and G are removed.
Yeah.
But if Your Honour looks at the bundle at page 14935, there's an upward amendment to the Aria Ukraine allegation, changing the sum recorded to the tracing workbook from around 20 million US dollars up to 69.9, so $70 million, more than threefold increase.
That's your client's workbook, isn't it?
I'm sorry, Your Honour?
The tracing workbook is FTI, isn't it?
That's the explanation, I think.
Your Excellency, actually, I think it's Matthew Britton himself is the tracing workbook. It's an exhibit
but it's
that he is sworn to.
the point I was making is it's a respondent document, not a claimant document.
Yes, that's right. It's just correcting million error.
Yes.
It's a quotation which is wrong, which has been correct.
Yes. So it emanates not from the applicant.
But, Your Honour, it is... it is, however, a change, and it's something which Mr. Britton is asked to answer to, and that has changed from an amount of 20 million up to 70 million. So it can't be said, we say, to add no prejudice. It also leads to an internal inconsistency, because I think there's a reference in the following paragraph. So again, we're still on 14935. That 20 million is retained there. It's not clear whether that ought to have been changed as well as the 69.9. But these are, we say, differences, and they're not, whilst in the context of normal commercial proceedings, these may be matters that could be, if not overlooked, at least excused or considered to have a lower degree of prejudice. But when we're in the context of contempt proceedings, RDC 52 is clear, and the authorities are clear, that the particulars of the acts of contempt must be set out specifically. So, Your Honour, we are now in a position where there's no final form of the allegations which have to be answered. And given that the amendment application is listed on the same day as the committal proceedings, then there's no clear light between the finalisation of those allegations and Mr. Britton's, the expectation that Mr. Britton will answer them. We say that that isn't procedurally fair, and it is contrary to RDC 52 in light of the court's additional requirements. So if we look at page 15404, RDC 5220, in dealing with any committal application, the court will have regard to the need for the respondent to have details of the alleged act of contempt and the opportunity to respond to the committal application. And then further at 5221, the court should also have regard to the need for the respondent to be allowed a reasonable time for responding to the committal application, including, if necessary, preparing a defence, and subsection 2, given the opportunity, if unrepresented, to obtain legal advice. Now, the question of legal advice is something I will come on to, because there's another, there are other important considerations there. But notably, Your Honour, at 52.22, following straight after those safeguards, the provisions relating to the striking out of a committal application are covered. And of course, the relevant one here is subparagraph 3, that there's been a failure to comply with a rule, practice, direction, or court order. And we say the non-compliance and the absence of any finalised form of the committal allegations is a stark failure to comply with the rule, practice, direction, or court order, and is inconsistent with the court proceeding on the matter in light of RDC 5220. So the position is that these allegations of contempt, as of now, are not yet finalised, and yet in an hour and a half, Mr. Britton is expected to answer in respect of them. So this goes to the heart of fairness in light of the context of the RDC 52 and the fact that we're in committal proceedings. Now, this isn't to say that the court hasn't done its best to try and ensure that things went ahead today as planned. And it's clear that Your Honour's order of June the 30th tried to put things in place that would allow that. That was, in fact, the first. The first time this was listed was, I think, the 6th of May. It was listed for the 5-day hearing. A point that the claimants make or seek to make is that this is something that has been adjourned 4 times. Well, that's not quite a fair representation, we say, because the 5-day format of the committal hearing was not in fact fixed until the directions of the 6th of May, and that's when the matter was set for the 27th to the 31st of July. So the only prior listings which were adjourned were 2-hour slots, and they were overtaken in any event by the claimant's own 30th of April amendment. So the 2-hour application that was listed on the 13th of April, the 2-hour hearing that was listed for the 13th of April following the original application on the 16th of March was never going to happen, nor was the subsequent one. And in fact, the other adjournment that was requested by the claimant was for further time. It was actually for the adjournment of a case management conference, and at the time the respondent specifically said, I'm not asking for the trial date to be changed. So this, in fact, is the first adjournment. This would be the first request for an adjournment of the 5-day full committal listing, not the 4th, as the claimants have suggested. Now, Your Honour, taking you back to 52, the strikeout provisions of 5222 are there as an additional level of protection for the benefit of the alleged contemner. And it has been intimated previously in the case that a strikeout application would be made, and that was in respect of the first iteration of the contempt allegations, because clearly they were non-compliant. There has then been indications from the court asking or directing that strikeout application, if it's going to be made by particular dates, and it seems to be relied upon by the claimant, who's saying, well, they haven't applied to strike it out, therefore they must have abandoned that course. Well, throughout, that option has always been reserved, and with respect, Your Honour, it is difficult to strike out something that has not yet been finalised. This is a moving target. You can't strike out draft particulars. You can't strike out amended draft particulars. And so, not knowing what to aim for, it's rather unsurprising that there's been no strikeout application, quite apart from the fact that the defendants are not legally represented. So this is an additional disadvantage that's arisen as a result of the claimants changing, by way of further particularisation, their claim as we were going along. the loss of representation, Your Honour, as I've said, is something which the court's aware of and at one point tried to fix. So when Horizons came on board, there was a directions hearing. And in the bundle at 1461, you will see an email from the court of the 6th of May giving directions for the hearing today, final hearing, with all the steps that were required to be undertaken. On the day after, sorry, the same day as this hearing, which is the next page in the bundle, 1462, there was the letter which I'm sure Your Honour is familiar with, in which the claimants were outlining to Horizons and Co. about their responsibilities attaching to any monies that they held, effectively saying that there was a very high level of due diligence and that disclosure obligations under 17.2 of the freezing order were such that ultimate source had to be disclosed. That really, Your Honour, is the battleground in the remedy application, although rather inconsistently the claimants say that they're asking for Mr. Britton to provide an affidavit giving the ultimate source of funds. At the same time, they're saying that that is already the standard that's expected. The interpretation they put on 17.2 already is not the plain words that we find in 17.2, but an enhanced format of that to give the ultimate source, a tracing exercise, even though that's not what the words say. So the letter goes to Horizons.
Sorry, can we just come up to date?
Yes.
So on this adjournment application, you're instructed by Horizons.
Yes, Your Honour.
And as I understand the position, essentially you and Horizons are acting for free on this application.
Absolutely, Your Honour.
But Mr. Britton, I think, said that he'd opened up another bank account to pay legal costs in the name of Aria, Commodities, FZco. Is that right?
There is evidence of this, and Your Honour may be aware of this because it was a subject of the Court Users Committee recently. It's been raised that when worldwide freezing orders are granted by the court, the Dubai onshore courts, being less familiar with them, send out orders freezing bank accounts. There's no exception. You can't pay your living costs. You can't pay your legal fees. And so this is the background against which a further account was opened. So yes, Your Honour, I believe that was referenced, and that I understand is the reason.
Okay. And how is the opening of that account not a breach of the injunction?
Your Honour, it may be, but that has to be formalised and put to Mr. Britton.
But
and he has to answer.
But as I understand it, FZco is just the renamed first defendant, because Dmcc, I forget the date, changed all of the names of DMC entities to FZcos. So it's just the changed name of the first defendant.
Your Honour has the benefit of me with that knowledge, and
well, I mean, it's on the evidence. It's in the evidence. I mean,
yes.
I mean, Mr. Britton uses the expression. He says unilaterally. I'm not sure that is right. It was announced, but anyway, leaving aside the slightly pejorative aspect of the word unilaterally, the DMCC changed its regulations.
Your Honour, that is something which, were Mr. Britton legally represented and here and answerable, and that had been levied against him as a charge, then.
So basically,
yes.
You're saying you can't help me on that.
I can't help, because the points that I'm hoping to address Your Honour on relate to whether or not the request for information about the source of funds goes beyond the standard request requirements.
This is just in relation to 17.2.
17.2, but also where Your Honour, on the 30th of June, made a slightly more specific direction that actually you need to tell the amounts as well as the source.
Yes.
Yeah, so you expanded it slightly there, but we say that still you can't read, that doesn't mean a complete upstream tracing history.
Yes, I understand the point.
So the reason why...
And for Mr. Peter's benefit, I have some sympathy with that point, actually.
Your Honour, none of the allegations of the substantive contempt allegations relate to that. They're all on different issues, and as a result, I don't have instructions on them, and I'm not familiar with them.
Yes, okay.
Your Honour, so as a result of that letter from Al-Tamimi on the 6th of May,
Yes.
there was then a response by Horizons, who effectively came off record, and you will see in the main bundle 1464. 1464 is the notice of change of legal representative. And it was for that reason, because there were suggestions that they may be holding the monies on constructive trust and that there may be a non-compliance. Now, the court became aware of that, and so on the 30th of June, amongst other things, ordered and Your Honour, you'll see that in the bundle at 1927 to 1928, ordered that Horizons and Co. or such other legal representatives as may be instructed are at liberty to resume, continue or commence acting for the first and second respondents, and then at subsection B, Horizons and Co. or such other legal representatives as may be instructed shall not, by reason of resuming, continuing or commencing to act, or by reason of receiving or holding funds paid as legal fees into the account given in the name of Aria Bio Industries FZE and in the name of Aria Commodities FZ Co. be in contempt of paragraph 17.2. As a result of that,
Yeah, I rather thought that had solved the problem.
Your Honour, one would have thought so, and that's why I suggested that the court did everything to, at that point, to put things on track and to ensure that there would be representation and that it would go ahead on the dates planned, with all of the things that might happen in the meantime being provided. However, that's not how things turned out, because Al-Tamimi, on behalf of the claimant, wrote on the 7th of July, well, let's go to the 6th of July of 15426. This is Horizons saying, following the order of the court, this is what we propose to do, to use the money, disperse council's fees, unless we hear otherwise. Following day, 15428, this is the response from Al-Tamimi. And this is where we get another pivot. Because originally we had the representation loss. And then the representation was restored, effectively, by the court's order. And then we get what it suggested, continuing representation blockade from then on, because following that email from Al-Tamimi, Horizons indicated that they couldn't continue to act. There were allegations that there'd been further failures to comply and that they may be holding funds on constructive trust. That is not something over which the defendant has had control. It is not Mr. Britton's fault that Horizons came off record. Now, part of the claimant's narrative is that both of these issues, legal representation and continued breach, are soluble at will. They say all Mr. Britton has to do is provide all of the information that they want, which is the full tracing history level, which they say they're entitled to, and thereafter he can go and get his legal representatives. But this, we say, is not something that Mr. Britton has to provide, and the soluble at will argument is entirely dependent upon the claimants having the correct interpretation of 17.2. So this, Your Honour, is why the matters are interconnected, and why Mr. Britton has not had legal representation since the 6th of July, despite Your Honour's efforts to get the parties into a position where he should have. The court clearly wanted him, and it's beneficial for a defendant in contempt proceedings to have representation. That's what should have happened. So, to this extent, it's the actions of the claimant that have led directly to the respondent not having legal representation. That is a significant prejudice. Now, the claimants say, well, he can get on with it anyway, and that the courts are used to dealing with people in person, and it seems that he is capable of providing witness statements for himself. So there's a picture being painted that fairness would allow the committal proceedings to continue when really that isn't the situation that the court has envisaged. He should have legal representation. He had legal representation. There's a representation embargo being imposed by the claimant, or a blockade rather, preventing him from being represented because of this argument that 17.2 hasn't been satisfied. Now, up until 10:30 last night, no authority had been provided by the claimants as to why they believed that there was a higher entitlement. There had been a suggestion that because this was a proprietary injunction and not a mere freezing injunction, that had some bearing on it. But as Your Honour will be aware, and as I've indicated in the skeleton argument, the proprietary nature of an injunction has effect on the use to which the frozen assets can be put. Nothing to do with the disclosure obligations and the standard proviso. That remains the same, and the plain words are the plain words. Now, what they've found, it seems, is some decision from
I'm not sure
Justice
I've seen
Peter Smith, if you've had that, Your Honour.
No.
Well, it may be something that you're taken to. It may, in fact, be something that the claimants, to be fair to them, they want to rely on in the committal part of the proceedings and not necessarily this application. But what it does, it's a High Court decision, and Justice Peter Smith says that in the context of that case, this additional obligation was there, but it was a very different case because this was a funder of litigation where his identity was in dispute. It was a question of who he was, if he existed at all, and that's why there was a higher level put onto it. There was also, it was also obiter because Justice Peter Smith made his decision based on another ground, and that was just something that followed. But it's also, and you probably don't have this case either, but it's also the subject of criticism in another High Court decision which we have provided. So,
okay, well, that's not unusual for decisions of that particular judge, no.
It isn't, Your Honour, and what that establishes is that it is not a settled position, and that if we rely on Stephen G's text and rely on Justice Foxton's decision referred to in my skeleton argument, then the plain words are plain words. They must say what they're supposed to do, and you can't go beyond them. So, nevertheless, the claimants have pressed for this additional disclosure and say that it's the standard. Now, that, of course, is also self-contradictory when it comes to the remedy application, because the remedy application tries to do two things, as I indicated. It tries to suggest that this higher standard ought to be imposed because there have effectively been breaches of the order. At the same time, it wants to persuade the court that this actually is the standard that's already in existence. But if that's the case, why do you need a remedy application? Why do you need to request the higher standard if that standard is already the default? Your Honour is aware that I'm not here for the remedy application, but this is the extent to which the remedy application touches upon the adjournment application. Because the loss of representation and then the second loss of representation are all consequent upon the exact issue that Your Honour tried to fix on the 30th of June. And Your Honour had no reason to believe that everything wouldn't go ahead after that. But of course, this is all happening in the background. Although Your Honour was, and the court was contacted by Mr. Britton to explain that he was again in person and the problems that he'd had. And this is why there was an attempt to request the adjournment, not just today, but a week ago, and to get two things really. It was to get clarification that your order of the 30th of June means what it says, and that there shouldn't be a continued attempt to have a different reading on 7.2 or Your Honour's order and suggest that the defendant's solicitors' horizons are in some kind of breach or potentially holding funds on constructive trust. So that appeared to clear things off, but not according to the claimant. They, very same day, sent the letter out, and that had the effect of the non-representation. So the non-representation is there. The absence of any finalised form of the allegations remains. Both of those significantly prejudice Mr. Britton, and neither of those are down to him. The further indication that Your Honour would like to hear from Mr. Britton, with good reason. There are many allegations and there are many questions that Your Honour would no doubt like him to answer. At the moment, and as was preserved by the freezing order, he has the right to silence. He doesn't have to speak. He doesn't have to give evidence, which may well be self-incriminating.
Well, he said that he's not going to give evidence.
Well, our instructions, my instructions today, are that when he says he's not going to give evidence, he's not going to give evidence in the context of not being legally represented and facing as yet non-final allegations upon which he hasn't been able to receive advice. So he can't get advice on the allegations. He can't get advice on whether or not he ought to speak to defend himself because he doesn't have lawyers because of actions that
So you're telling me that he may give evidence if so advised. He may give evidence if having had the benefit of legal advice is essentially what you're saying.
Yes, Your Honour, in relation to two things. First, whether, having seen the final version of the particulars of contempt, and then secondly, whether to give evidence in light of his right not to self-incriminate.
Oh, I know. That's why I say may.
Separate.
I underlined twice the word may. Okay. Yes, I understand. Yes, he can't be forced to give evidence.
Your Honour, he can't, but in circumstances where he isn't...
Of course, his evidence, I mean, of course, and there is a suggestion about this, no doubt Mr. Peter will make it in due course. If he does provide an affidavit, but declines to be cross-examined, the court has a discretion to disallow the affidavit evidence.
Yes.
And just thinking through that, unusually this is a case where there may be expert evidence as well. If the court were to exclude the underlying evidence of fact upon which an expert evidence is based, it would have to exclude the expert evidence as well, it seems to me. But anyway, those are bridges to be crossed if and when we ever get to them. That's just a little thinking out loud.
Your Honour, yes, and it's right that the opportunity was given to him to have expert evidence. The claimants have put in expert evidence,
yes,
and voluminous documents that have come from the claimant's disclosure, but from the respondent's disclosure, but not necessarily something that that Mr. Britton is familiar with to the level of detail that would be required in a contempt application.
Yes, I mean this is an unusual contempt application in some respects because of its complexity, its financial complexity.
Yes, Your Honour. And Your Honour, the court will want to achieve something purposeful from a contempt application, not just listen to Mr. Pito read out his pages of allegations which are not responded to, and to which you then just make a decision to what end. That doesn't really get Mr. Pito what he wants. It doesn't get the court any answers, and it doesn't give fairness to Mr. Britton.
Well, I mean, where we're at the moment is that the committal application is uncontested.
Well, Your Honour, there's
no evidence in response to it.
There's no evidence that, apart from the witness evidence that Mr. Britton has.
Well, that's on witness statements. It's not admissible.
Well, Your Honour, yes, and this rather emphasises the prejudice to which Mr. Britton has been put, because whilst he may be able to draft narratives of fact, he isn't able to understand, or hasn't perhaps gotten to the nuances of the requirement that in contempt proceedings the affidavit must be.
I have to say his witness statements are fairly nuanced.
As to fact?
Well, they're rather sophisticated documents. I am impressed by his legal knowledge.
Your Honour, the resources are available now.
No, I'm talking about the earlier ones.
Right. Well, Your Honour, it may be that some of Mr. Montague Smith's talent brushed off onto Mr. Britton, to his benefit. But Your Honour, the depiction of where we are now by the claimants looks as if this is something which they want to get on with, the court should want to get on with, and that Mr. Britton is solely responsible for delaying. And what I wanted to impress upon Your Honour this morning is that that's not really a fair description of what's happened, and that because of a number of circumstances, the main two of which are changing nature of the allegations and his lack of legal representation, neither of these are down to him. Against a background where Your Honour can now see why this isn't just a case of ignoring what Your Honour indicated on the 30th of June. And this is the first time that Mr. Britton has asked for an adjournment of these proceedings, and in circumstances where, with representation and with a finalised version of the contempt allegations, the court it has a good prospect of being able to determine this matter in accordance with RDC 52, and in a way that recognises the fairness that Article 52 requires. So, Your Honour, I've taken up at least 3/4 of an hour now of the court's time. I'm happy to face any further questions from Your Honour, or if you give me an opportunity to respond to Mr. Peto afterwards.
You'll certainly have an opportunity to respond.
I'm grateful. Thank you, Your Honour. So that's my application is for, as you will see, a short an adjournment followed by a case management conference shortly thereafter to fix further dates.
Yes.
Thank you.
Thank you very much.
Thank you very much.
Peter.
Yes, yes, Your Excellency. First, just some broad brush points, and then I'll come into some detail. So, effectively, what is being said is, if you decide to misappropriate fraudulently a large amount of money, which is subject, therefore, to a tracing claim, you refuse to say what you've done with it after repeated orders. You then get subject to a committal application as a last resort for the court to try and enforce its own orders. And then you say, well, because I pinched that money and I can't use it to defend myself, I shouldn't have to face committal. But that's the kind of broad brush position that we're finding ourselves in the real world. Also, in this case, the respondents have tried every which way to delay this trial. First excuse being an inability to pay their lawyers to defend them because of that proprietary point. They've used this excuse not to work on the committal for 4 months, despite still finding large sums to pay lawyers only last week to defend an application against their wholly owned subsidiary, Aria Bio. Your Excellency dealt decisively with this excuse about not being able to use proprietary funds by making that order on the 30th of June, specifically immunizing their lawyers, Horizon, from liability for contempt or knowing receipt if they received such funds. Now, that should have been enough to dispose of that excuse. Now, Your Excellency imposed an entirely necessary condition in that order, which I'll come to in due course, that the respondents disclose the source of such funds. And they failed to do so, despite it obviously lying in their power, and they're trying now to say that the application of that condition is unfair or its meaning is misunderstood. And we'll come to that in more detail later, but the immediate headline point, Your Excellency, is that Your Excellency's order says you're allowed to take money out of these 2 bio accounts, and then you're immunized from liability for knowing receipt or contempt. But respondents have got to say what the source is. Now, obviously, it's not going to be enough just to say the source is the accounts that are already mentioned in Your Excellency's order. It's got to be more than that. So that means that really the interpretation of the standard form of exemption, the paragraph 17.2, which is to be found in standard form freezing orders, really doesn't really have any effect or doesn't have any impact. This is a tailor-made order that Your Excellency made for a tailor-made situation,
Let's
was
just
one.
Let's just go to the order. So it's page 1927.
1927. Yes, it's paragraph 4, 4A, that Horizons can continue to act, and B, that if they do so, if you get the accounts from these accounts, these named accounts, the name of Aria Bio, Aria Commodities, then it won't be a contempt, and you won't become liable as trustees. So Your Excellency has already said this money is given a source, inverted commas, a source of these 2 accounts.
I'm just trying to pass. I'm sorry, I'm getting some feedback. I don't know whether it's from Mr. Peto's loudspeaker or not. Anyway, if we look at 4A.
Yes.
So Horizons and Council. Has anybody else got their speaker on other than Mr. Peto? Because it's extremely annoying feedback. Now I've got no feedback, but I can't hear you, Mr. Peto. So
Maybe I'll mute when Your Excellency is speaking, and then I'll unmute when I am.
It's good. Yes, thank you very much. So 4B, Horizons and Council, other representatives, shall not, by reason of resuming or continuing or commencing, etc., by reason of receiving or holding funds paid as legal fees from account in the name of Bio or an account in the name of Commodities FZ Co, be in contempt or incur liabilities constructive in respect of funds, provided that before spending must inform the claimant's legal representatives the amount to be spent and the source of the funds. I'm not sure I'm with you on the interpretation of those words, the source of the funds, meaning anything other than which of those two accounts or another account from which the money comes. I think that's where you have to persuade me that it is a more onerous duty upon Horizon to indicate the ultimate source, tracing it back to wherever.
Your Excellency, the first point I guess to make is, I mean, Your Excellency said that the obligation would be to specify which of those two accounts they were taking the money from, or, as Your Excellency said, what other accounts the money might have come from before it was paid into those two accounts, one of those two accounts.
I didn't say or other accounts before it was paid into. It's whether the money goes to Horizon from either of those two accounts or another account.
And if it were to be from another account, well, the thing is, this order on its face only allows those two accounts to be used.
Yes.
And in order to achieve the immunity. If in fact, to analyse it, if all that was, I mean, and I should say, first of all, in the correspondence shows that the order that was being sought from Your Excellency by the defence was an order which was simply to have permission to use one of those two accounts.
Yes, I mean, the mischief, I think it's exemplified in the decision of Mr. Justice Foxton, as he then was, is to identify whether there is any diminution of an account which is caught by a freezing order.
If we I'll come to that in just a second. We'll come to Mr. Justice Foxton's judgment.
Yes.
It's just that here, if primarily, I mean, I'm saying the history of this order was they asked for an order in those terms without, Your Excellency then added the proviso about having to state how much and the source. Now,
yes.
Objectively, on the face of it, that means the obligation to provide the source has got to be giving more information than what is already in this order. This order is saying it's fine for you to use one of those two accounts. Then saying, well, you've also got to say the source must mean something more than mentioning the two approved of accounts is already there. Otherwise, it's redundant.
I don't see that.
And
I don't see that. You've got a choice of two accounts, both of which have been disclosed and are caught by the freezing injunction, and they've been exempted for this purpose from the freezing injunction. But you have to disclose how much is coming from those accounts, because it is essentially money into which your clients could have traced, hence the argument about Horizons being constructive trustees.
Well, that of course leads to the other point, which is because this is a proprietary case, slightly stricter considerations apply than they would with if someone was spending their own money, or what was unarguably their own money.
Yes.
But it's but we're not talking about. It's slightly overstating the case to say that we are asking for a complete tracing exercise. When one talks about the source, one means the source doesn't mean I've got money in my left-hand pocket. I'm allowed to use my left-hand pocket, which is called Commodities. But all I've got to do is to say that I've taken the money from my right-hand pocket, which is called Aria something else, or my own. It means explain where the money has come from outside my own estate. So has the money come from X company to which I sold something, and the money then is something which has come into me from that. So that's then the source.
I don't see.
Or from my auntie Agatha that left me money in a will, which of course would be another source.
But practically speaking, how does this work? I mean, Aria Bio is a trading company, and you and I both know from evidence in other parts of the case that it's in a fairly substantial way of business. Aria Commodities, FZco, also engages in many different transactions. How do we? And money, of course, is fungible. So how can we go beyond the fact that the money has emanated from the accounts of one or other of those entities?
Well, that of course would depend on the specific circumstances of where that particular fund had come from. But this isn't asking the impossible, or far from it. In fact, already the other orders which the court has made to require a tracing exercise to be done, the orders about saying this 456 million have come in. You must say now what's happened to it, and
that's
at every stage.
I mean, we're many orders of magnitude greater in terms of sums. Although I'm sure Horizons don't come that cheaply, but not $456 million. I mean, it just seems to me practically, I think we're talking at the moment about 650,000 dirhams is what they say they're holding. How you can trace that back to the business of Aria Bio and where that money actually comes from, I'm finding hard to understand.
Well, I don't think it's been alleged by the other side that it's an impossible task. They can't do it. They're saying it's intrusive, which is a strange thing to be saying in a case which is already.
I find that not an attractive position.
But they don't say they don't say they can't do it. They rest their case upon the interpretation of the order and say it's intrusive, but they haven't said can't do. And if they haven't said can't do, then we shouldn't be assuming they can't do. And the important thing here is that since I'll come to Mr. Justice Foxton's judgment in a moment. The important thing here is that they're saying, oh, it's not our fault. The court made this order about, which is a pretty unusual order, and one which shows quite a huge amount of degree of indulgence, bending over backwards, to be fair to them, fair enough, that their lawyers can't be sued for using money that may be traceable. And they're saying, well, we couldn't use this order, very convenient for them in a sense, because of course they want to avoid these proceedings. Let's not lose sight of the fact they've been trying to delay things. Is it now 18 months since we first got this order? Still, we don't know what he's done with the money. So what they could have, I don't say they couldn't have, indulge us a little by saying, well, all right, you say that's what the order means, we don't agree, but since we want to get on and defend ourselves and we want to demonstrate our innocence for the whole world to see, anxious to do that, desperate to clear our name, we'll tell you where this particular money comes from. It came from, if you look here and look here, it came from these particular trades or whatever. There you are. Now let's get on with it. And they could have done that. Then they tried to say, oh no, it's the claimant's fault for asking a question they shouldn't have done, and they hide behind that. But they haven't said that they can't do it. I mean, doubtless when a friend will take instructions in reply, and those instructions will be, oh no, of course we couldn't, and that of course is entirely predictable. If we look at Mr. Justice Foxton's judgment, which I think is at 15571, and if we take a look there, I think the internal page of the judgment is that right? 15571, the internal page, it gives the internal page of judgment, page 792, paragraph H, I think it is. Yes, it's between G and H. It's little 3. I mean, the main point in this case was about having to, whether they had to state the amount they were spending. The obvious reasons why the court may include a requirement respondent identify the source from which legal expenses are being funded are A, to ensure the sources from assets disclosed in accordance with the respondent's disclosure obligation, and B, particularly if the freezing order is worldwide, to put the applicant in a position to take steps if it becomes apparent respondents using assets which would otherwise be more amenable to execution to meet its fees, while leaving assets which it would be more difficult to enforce against if untouched. So this is dealing with a non-proprietary claim. And that's dealing with the rationale of your standard, say where the money is coming from. Now, if the point is to make sure that it comes from assets which have already been properly disclosed or assets which are not being easily denuded, that rationale means that just simply stating a given account that we already know about isn't actually going to, isn't going to quite cut the mustard. One does need to know where it's coming from before that. And if one says coming before that, the money is coming from X and Y and Z Limited who were paying for services, and that's where it comes from, well, then we know. If it's coming from another source that we don't know about, Mr. Britton's secret bank account he hasn't disclosed, say, or a bank or an account which is more easy to enforce over, then that's all we need to know. So the rationale, even in a standard form exemption, as in paragraph 17.2, this indicates it's rather more than just identifying which of 2 already identified accounts the money is coming from. So they've got to do a bit better. Well, I'm not saying they've got to go through an exercise which necessarily involves going through 100 different stages, but it's not impossible to say that the money which you have sitting in that account has come from these 3 trading contracts, or it's been transferred from another account somewhere else. That is actually not impossible. Actually, it's dead easy, and they don't want to do it. They don't want to do it, doubtless, for the same reason as Mr. Britton, as all this evidence shows, hasn't wanted to say what he's done with these hundreds of millions of dollars, because the evidence shows that he's only been giving not even half a story, but a fraction of a story about where they've gone. He even admits in his disclosure, I've usually only said the one step where the money's gone and not said what's happened afterwards. This is all of one with his policy of trying to conceal. It's not surprising. That is really what's behind it. And that's why he doesn't deserve to come here with his fingers in his eyes to the court saying, I'm so unlucky, haven't been able to get lawyers because of those beastly claimants who are making me say something which I don't have to say, although I could say very easily, and it's all at one with the kind of disclosure which the courts have been asking me to do. It's if one has a look at the history of it, one sees that really this has been a somewhat sorry exercise. First of all, our initial notice of motion to commit was perfectly fine in terms of its particularity. We don't accept at all that there was anything wrong with it. It sets out what the provisions are. It sets out that he didn't say what he'd done with the money. He didn't give all the sources, and there was an affidavit in support. But they then came along and made an application, said they wanted to apply to strike out.
No, in fairness, I was, I think, the first person to raise the possibility that the committal applications originally drafted was problematical.
Maybe so, Your Excellency, but that we never got to the stage of actually arguing that toss. Our submission would have been that it was within the rules, but certainly could be more conveniently maybe dealt with by spelling out what in fact was already in the existing material. And we didn't plead anything that wasn't already in the existing material. So went along with that. They threatened to strike out. In response, we provided the particulars. 30th of April it was, in draft, and directions were set out about how that could be dealt with. And I think maybe that's at page 1924. Yeah, and there, the directions were given there. I think that was the date on 6th of May, that was. Yeah, and so since the other side has said that they wanted to strike out, we said that, and we'd already put in our amended draft, something which my friend keeps saying, non-finalised, jolly unfair, doesn't know, moving target. This is rubbish. 30th of April, they knew exactly what they were facing, and that's been, what, 3 months ago? They've had that, they know what that is. So they've got to say by the 12th whether they want to oppose it or whether they're going to do a strikeout. Well, they still haven't told us now. You know, it's we still have this unopposed application to amend, and then they were supposed to file evidence, which they didn't do either. That we were going to respond if there was any. We didn't need to. Of course, no responsive evidence needed by 4, and then by 29th of June, there was going to be evidence in opposition relied upon, and then there were directions for committal coming down for today's date. Now, they haven't complied with any of that at all. The only thing they did do was to put in a holding skeleton last week, which doesn't really count as a skeleton on the merits. So there's been a complete absence of cooperation with any of that. We still have, so no strikeout applications even been made now. So I didn't hear my own friend saying that our original particulars were liable to strike out. Didn't hear anything about opposition to these ones.
I don't think you need to address me on a strikeout that hasn't been made and may never be made. And indeed, then, whether I would permit it to be made at some point in the future if it came to it.
No, I won't. Well, I won't do that. I'm just trying to say how, in the round, there's no unfairness here. Is really the point. Is that they had notice of the main allegations back in March. Since the 30th of April, they've got these particulars which, in our submission, are completely unobjectionable. I mean, they go into exhaustive detail with some repetition of precisely spelling out the obvious, we would say, but still spelling it out. And they've had that for 3 months. They were trying to string things out a lot worse. One takes a look at the, maybe I don't need to take a lordship to, it's paragraph 5.1 of our skeleton sets out the directions they were asking your excellency for then, which their skeleton is at S1, it's 15461, I think. Sorry, ours. Sorry, 15461 is our skeleton, where we set out paragraph 5.1, just for convenience here.
Sorry, what am I looking at? 5.1?
It's I'm looking at 5. Yes, I'm sorry, looking at paragraph 5 about our skeleton opposing the adjournment application. I'm sorry. Maybe that's the wrong one. No. So,
page 15462. No.
Yes, yes, that must be right. Yes. So, in paragraph 4, we referred to the directions that I just took, Your Excellency, to, but in paragraph 5.
I mean, the point you're making is on the next page, isn't it? That they'd asked for an adjournment essentially to the after the 30th of October.
That's right. We wanted it to be until sometime in November or plus, and that was all rejected. And Your Excellency gave this other carefully worked out timetable for it, which was fair then, and we still say was fair now. Now, the respondents have been aware about this issue about source of funds since April, because in correspondence in April of this year, we were already crossing swords about this source of funds issue. Admittedly, that wasn't yet didn't relate then to Your Excellency's order of the 30th of June, but still it's a point in principle is there. One can see that one looks at page 14679. And
14679.
yes.
Yep.
And it's the it's the last paragraph before the it's little one asking for the source of the funds. And then looks at, sorry.
So please confirm as a matter of urgency whether the funds being utilised towards Aria Commodities DMC legal expenses pursuant to the exception are our clients' monies, and if not, the source of these funds.
Yeah. Which is not an unfair interpretation of actually what the standard form in 17.2 is, because we're dealing with a proprietary claim here. And then if one looks at page 14682, so just pages on. We see in paragraph 3 somewhat oblique response there. Certainly doesn't specify precisely where they come from, and certainly doesn't deal with anything to do with the proprietary claim. And then one looks over the page at 14683. One sees the complaint that is made in the third paragraph, the explanation, the letter, sorry, paragraph 2, the second one. So we complain that's not good enough in paragraphs 2 and 3, and the then there's finally page 14709. So one sees there from paragraph, well,
Sorry, what you wanted to make a point on 14709?
147, yes. Well, I see there that the position taken there is that they don't have to give us any more information than they already have. So, I mean, we've locked horns on this now in April. But another further point to make in paragraph 5 is they say that as a gesture of goodwill, without any obligation, they're going to tell us that the firms receive payment from two accounts. So they say they don't have to do it, but they're going to do it anyway. And they mention the two accounts, which I think are the two accounts which they then
Yes,
put
I
into the
think
draft order.
I think the chapeau to that paragraph is wrong.
I beg your excellency's pardon, the what in that paragraph is wrong? Sorry.
I think the chapeau, saying as a gesture of goodwill without any obligation, is legally wrong if you read my order.
Oh, I see. Sorry. Well, yes. It's the other thing though is that this just goes to show how important it is to go some way towards our interpretation of this order, which isn't enough to say, oh yes, these are two accounts the judge said we can use. We just have to say which one it is. Look, 5B, our inquiry has actually uncovered the purpose of having this source, which is that Mr. Britton, in contempt of court, hasn't actually provided one of his bank accounts, an account which in fact is controlled by him. We say, never mind whether it's actually contempt. We're not complaining about that, but we have to formally find that. But we're informed by our client that this account does not appear on the asset disclosure list. So it's uncovered something we needed to know, which is what the source was. And that's all we're asking for again this time. Is what, in fact, by ultimate source, you mean, but where did the monies come from, which you put into this account? And that's not, and that is a reasonable thing to ask. It's within the rationale that Mr. Justice Foxton, as he then was said, is why we have that order. It's the absolute minimum as to what Your Excellency was requiring in his order too. So, and they've known about this since April. This isn't a recent point. They say in their evidence, this only crystallized sometime in the teens of July. I've forgotten whether it's the 13th or the 17th, they say. This has been around since April. But if you know that something's going to cause a problem, which might fracture, might break a trial, you need a German, then the rules of the DIFC say that you've got to immediately make the necessary application to get the court. If we take a look at the Practice Direction 1 of 2026, sorry, I haven't got the reference for that. While my 15581. That's 15581. This is a general principle in 2.3. Parties must continue to prepare for any listed hearing unless the hearing is going to be adjourned. So the fact you're going to apply to do it doesn't stop you getting on with the work. But specifically, if we look at practice direction, it's 4.2, I think in the same, yeah. Contested request to adjourn. You've got to make an adjournment. The application should be made immediately upon the circumstances giving rise to the request becoming known. Now, they knew about this issue in April, months before Your Excellency's order of the 30th of June.
Well,
so
what they say is that the position was fixed until in July. Your instructing solicitors or legal representatives said it's not good enough just to disclose the accounts they've come from. You must disclose the source of the monies before it went into those accounts. Otherwise, you'll be constructive trustees, and it's their case then that what date was the 6th or 7th July? I can't recollect which.
Yes.
That was when matters really came to a head.
Well, they may say that, but it's very clear from the correspondence which I've taken Your Excellency to, that we were already saying, look, you've got to say where this comes from, to say what other source, whether it's our monies or somebody, or if not ours, then somebody else's. And we also took the point before, in our skeleton before the second directions hearing. And we're looking here at paragraph 31. If one looks at 1540, Your Excellency, This is about 60. This is I see it's quoting from us. Oh, I see. This is from Mr. Balla's 16th witness statement, which is quoting from Muscovison, just to be clear. But that the quotation there saying that.
Sorry, which paragraph?
This goes 31.3. Paragraph 29 of the Skeleton argument, which Horizons got on the 1st of May. Disclosure as to sources of funds used for legal expenses under that heading. The responses given by Horizons are plainly inadequate. Horizons should have satisfied itself whether any monies which it has received or will receive are the traceable proceeds of the DMCC payments. So they know that this is, they know formally, because it's an argument before the court, that this is a point which is live. So it didn't really come live on the 6th or 7th of July. It was reiterated, but it was really reiterating a position which had been around for months. So
practically speaking, how do you satisfy that? How do you go back to the original 6 remittances and trace money all the way through to what's paid into Horizon's client account? How do you do it?
Well, by looking at the bank. Well, you look at the bank statements, and you're in control of all of them, and you look through the bank statements of the companies it's gone through, and you see what's happened to it, which is precisely what actually Your Excellency has been ordering them to do since February of last year.
Yes, but that in itself is the substantive disclosure exercise.
Yes.
I mean,
so,
if you'll forgive me, I mean, it seems to me that this is being used as another route to get that disclosure.
Well,
you may well be entitled to that disclosure, and the first and second defendants may well be guilty of contempt in not providing it. But I'm not overwhelmingly happy that this is the route to go down to get that disclosure.
It's more like this, Your Excellency. It's more that the order says the source, and we say we submit that means, especially in a proprietary claim, that you ought to be saying whether the source is a source which is a proprietary source or not, in order to protect a proprietary claim. Now, in opposition to that, it said against me, that is really unreasonable. That's intrusive, unreasonable, not a correct route. Our response to that, which seems to be entirely unanswerable, is you can't say that asking that question is in some sense improper or inappropriate, because the court has ordered you to say what has happened to all the proprietary monies. So it's not inappropriate for you to be telling us whether this particular fund comes from the proprietary funds, because the court has said, tell us what's happened to the proprietary funds and tell us where they are now. So all we're asking you to do is part of the very thing that the court has ordered you to do twice. So that's how one puts it. The way you actually put it, which is it seems like another route to get there.
But what if the money had in fact derived from the 6 remittances? What would be the situation for Horizons then, if the money in their client account had emanated from the 6 remittances?
The position would be, because of Your Excellency's order, is they will be immunised from liability, either for contempt or for knowing receipt. So Horizon would be in the clear, which is fair enough, because they're third-party lawyers who are being asked to do their job in the interests of justice. However, Mr. Britton would quite rightly not be in the clear, because if he's using that money for that purpose, he's liable for knowing receipt or for contempt, but his lawyers aren't, because of the immunisation of the order. Or it's because the money is coming from an undisclosed source, which is the other reason that Mr. Justice Foxton gave, which is a reason which is not dependent on there being a proprietary claim. But But look what happened when we actually asked them to disclose the source. We jolly well found out about an undisclosed bank account. So that's the reason why, and they say you weren't entitled to that. We're just telling him with goodwill. And Your Excellency, I respectfully agree, is right. It wasn't goodwill. But it yielded a result that gave us protection. We're asking for the same now. It's not unreasonable. It's all falls of what the purpose of these orders are. So there's no adverse consequence for Horizon. But we are entitled to know if Britain is dipping into our money to do it, even though he does get to use it to defend himself. And then, maybe having used it to defend himself, then in some way, somehow he's in the clear for contempt. But we'll know that he would have been in contempt if he'd, or he would be liable if he'd been using our money. So Horizons are safe. This disclosure of source obligation keeps them, it doesn't stop them being safe. So there's the, sorry, I was looking at, I think I looked at rule 4.2. If we take a look at, I think part 26 of the rules, the case management rules, this is now of the courts, it's rule 26.85, which is at 15.583. Where the court won't allow a failure to comply with directions to lead to the postponement of the trial unless circumstances are exceptional. Well, here, clearly, there's been a wholesale failure to deal with the defence. Have entirely failed to comply with the directions, 6th of May, by not stating whether they want to strike out or oppose the applications, by, if they did, putting in evidence for it, by putting in evidence on the committal if they so chose, or putting in a substantive skeleton argument. They completely failed to do any of that. And this rule doesn't say that being temporarily without lawyers lets you off necessarily. There has to be something exceptional. Is this exceptional? Our submission is the only thing that's exceptional about this case is the wholesale failure to cooperate, the wholesale failure to comply with orders and directions, and to lead this court and also the claimant on a wild goose chase now for some 18 months since February of last year, with a huge amount of time and cost wasted, time of the court, time of ours and our costs, in non-complying with these orders. And now there's this last-ditch attempt at the last minute to try and put off this committal, which is so necessary. And so the exceptional circumstances are exceptional in the sense of bad behaviour by the other side. If one takes a look at the principles set out in Milan Friends' skeleton argument, which I think one can find it, it's 15509, I think.
That's the first page.
Yes, that's right. If one goes on to internal page 4, so that would be the 4th page of it, there's some...
Yeah, it's 15512.
I'm sorry, yes, that's right. So if one looks at paragraph 3.2, where my learned friend sets out helpfully some of the adjournment principles, it's a bit of the penultimate line. The parties must continue to prepare until an order is made. So we haven't got any evidence that Mr. Britton has been preparing at all for this trial, which has been listed since 6th of May. One looks at paragraph 3.3, we respectfully agree with the principle set out by my learned friend. The court approaches an application to adjourn with a considerable degree of caution, will only contemplate an adjournment if it's really necessary to achieve justice between the parties. And it's reinforced by Corinth case, sorry, by the cases there cited, and by Rule 26. postponement of a trial is order of last resort. He won't postpone without a very good reason. And in 3.4, the point is made that whereas in ordinary civil proceedings, the absence of a defence might be a relevant consideration to deny an adjournment, it's submitted that that doesn't apply in the same way or I think it's submitted there at all, in a committal application, which has a quasi-criminal element to it. Our submission would be this, is that it seems reasonable that the absence of a defence, or apparent absence of a defence, would not have the same automatic connotations it does in a civil case, but that still it must be a factor which will be taken into account in the court's discretion. Well,
there's a right of silence, and given that it's a quasi-criminal jurisdiction, a person who is accused is entitled to say, prove it.
Yes. And we are in a position to do that.
Yes.
What we say.
You say.
So it's so we say. The point is that if in fact we're in a position where there's no positive defence has been advanced, although enough of this committal has been around since the 24th of March, when it was first emailed to Mr. Britton, and formal service, the date was the 30th of March. It's quite a long time to work out a defence if you've got one. And he had legal advice from then until the 7th of May anyway, on his own story. The additional particulars that we put in to spell out what we say was already implicit, 30th of April, there's been plenty of opportunity to actually enunciate a defence. Also, there's the fact that Aria Bio did fund lawyers quite substantively for a contested hearing only last week, put in a cost schedule as well. Now, appreciate that counsel appearing for Bio made much of the Salomon and Salomon principle and the differences of legal personality, but still, it doesn't alter the fact that Mr. Britton was is the UBO of that company. They managed to find funds for that. So it's difficult to imagine he hasn't been able to have access to some legal input. And also the style of his letters is either something's rubbed off on him, or he's very good at it. But the position is nonetheless, we do have to prove it to the criminal standard. We say that we're in a position to do that on the evidence that we have in court today, which would be a matter for Your Excellency to determine, but that's our position. If he's not going to put in the evidence in response, and he hasn't, and unlikely to, that means that can be taken into account in the sense of whether an adjournment is going to achieve any greater amount of justice than not. And if there were to be an adjournment, we can all bet our bottom dollar, and we all can know in our hearts that we'll be back in this position again later on, with exactly the same kind of arguments being made, or counsel turning up saying that Mr. Britton's not going to come to court. He's broken Your Lordship's order to turn up. He's effectively a fugitive now. I mean, so we're going to be in the same kind of position. So I agree with the submission here that the absence of a defence is not to be given the same weight as it does in a pure civil case, but still the absence of anything having been enunciated must, in our submission, be a relevant consideration. If one takes a look at the checklist in paragraph 3.5, which my learned friends helpfully put forward, there's these factors which a court might take into account, whether it should proceed in the party's absence with regard to an adjournment. This structured checklist here. The factors are, one, whether the party's been served with relevant documents, including notice of the hearing. Answer, yes, a long time ago. And the draft amendments, 30th of April, that's what, 3 months ago. Whether there's been sufficient notice to prepare for the hearing, yes. There has been. The reasons for the absence of non-readiness, well, the reason for absence is in person is somewhat, hasn't really been evidenced why the order for the defendant to turn up has been broken. One thing which is a matter of some concern is one of the reasons given was that Mr. Britton was concerned that should he turn up, that if there were to be a travel ban on him imposed, he wouldn't be able to come back. Well, I mean, that's the very point, because in committal proceedings, that's not something which is at all impossible, to have a travel ban if there's a possibility of a custodial sentence. I appreciate that that's dependent upon the authorities in Dubai.
Yes, I mean,
Still,
I can tell you that this court does not have the power to impose a travel ban.
It does not. But if his concern is that the authorities in Dubai might be asked for one on the back of this, and that's why he doesn't want to turn up, that's not very meritorious. But I appreciate that this court doesn't have the powers to ban travel or to impose prison sentences, but has the power to notify the attorney. 4, whether the party knew of the consequences of proceeding in its absence, well, yes, it obviously does know that. Would the adjournment be likely to secure attendance? No, unlikely. Facilitate representation? Well, they say yes. We say, well, you could have had it anyway. The extent of disadvantage not being able to present its case, well, that's hard to know because we don't know what their case is. But one thing which does seem clear, and this does feed a bit into a criticism that my friend made of our original notice of motion to commit, is he said it doesn't enumerate the acts of contempt or the dates on which they were committed. Well, that's because the acts in question are nearly all acts of omission. The main thrust of our committal is you haven't said what you've done with the money or where it is and what happened to it. So it's an omission. So here, it's quite difficult to know what the defence would be. I mean, he could say, well, no, I actually did say, you haven't read it right, I suppose, or he could say, well, the meaning of the order didn't mean I had to say, but that's not very likely either, because he has actually purported to comply in a, not even a half-hearted way, but maybe sort of a 1/10-hearted way. So it's hard to know whether there's going to be any disadvantage there. In fact, it's most unlikely to be any disadvantage there. The only thing which he might have some advantage is in mitigation. We got no idea. It's not like saying you broke a restraining order because you were seen within 10 meters of your ex-wife's house and you were told to keep her out of that town. No, I wasn't. I had an alibi. Obviously, then, if you've got an alibi, then there's going to be a dispute. Here, there can't really be any serious dispute. The man hasn't given the information that he's been repeatedly ordered to give. So, most unlikely to be a disadvantage. Whether undue prejudice would be caused to the other party by delay, that's us. Well, it comes on top of the fact that since March of last year, we haven't had answers to the questions that Your Excellency has asked about what's happened to nearly $500 million of, we say, misappropriated assets. Now, I mean, our client's lost that in terms of prejudice, and this committal application is designed to enforce these orders. And we hope they will have that effect. But this is the extent of what the law's power is to try and compel obedience, to protect major property rights amounting to that huge sum of money. And we're being kept out of that money again and again. The longer it goes on, the longer the prejudice, the greater the chance that the monies, even if traceable and enforceable, will now go beyond reach. And there will be an element also of a further irrecoverable cost if we have to adjourn. Although I don't major on that very much. That will be modest, but still some. Whether undue prejudice will be caused to the forensic process, well, we say no, because it's really all on the papers here. It's what he was ordered to provide, it's what he has provided, and we can see he hasn't done it. So, in a sense, and because there's no suggestion there being any evidence against, there wouldn't be any.
I think you've got that the wrong way around, haven't you? Is whether the adjournment would cause undue prejudice to the forensic process. Now, your case is that it would.
You're right. I put the submission entirely the wrong way around. Yes, it is.
I understand. Yes.
Yes. Sorry. I think it's your obvious point to say. Overriding objective is make people obey the orders that the judges hand down, and especially when it's $500 million at stake.
Well,
And
forensic process. Well,
so,
actually,
yeah.
it's the other way around. Forensic process is to obey orders, and overriding objective is dealing with matters expeditiously.
Yeah. Yes. So I'm sorry to have gone through those.
That's okay.
Points. It's so that's the checklist. It's there's I should say, by the way, your basically slight concern about whether it would be onerous for them to say where the money came from. We have to bear in mind that we're talking maybe here about bio. Now, at the last hearing, bio was represented by counsel and by solicitors. It was clear, of course, that Mr. Britton owns and controls bio, since the managing director admits that he takes his instructions from him.
And he's the ultimate beneficial owner.
And indeed the UBO. They admitted to having copious records. They even were offering to put forward, instead of having it submitted to a disclosure order, some kind of very solid and massive report that would effectively give us what we wanted. They've got all that information to be able to say about buyers' financial history and affairs. And they're not quite saying this, but they can hardly come forward now and say it'd be awfully difficult to say where this amount of money would come from, because they've got all that there. I mean, also what's significant is, if one looks at the first affidavit of Mr. Britton, if we take a look at page 2934, and one takes a look at, this is Mr. Britton speaking at paragraph 68, he says, I've supervised a team of 7 accounting and financial personnel across a number of jurisdictions to investigate and provide information in relation to the assets of the Aria Group, including Aria Dmcc. So he's got 3 people centrally in Dubai. He's also got, he says in B, 1 person at Aria Bio who's doing this job. Tanzania and South Africa doesn't really matter, but it just indicates he's got the resources to be able to do this. And it was actually saying, well, I'm devoting a whole team to this. Of course they can give the information we're asking for about where the money's coming from to pay these lawyers. Of course they scarcely dare to say they can't do it, because of course with that kind of evidence, how can they? Although doubtless, but then we'll get instructions from Mr. Britton now saying, oh my God, it's more difficult than climbing Mount Everest. So they could very well, even if we were asking for more than they thought we were entitled to, they could jolly easily have given the information and then funded their lawyers if Mr. Britton was really desperate to clear his name. So this has been caused by their own actions. It's as regards the actual amendments themselves, it's a point was made about the amendments to the amended application last week. I think Your Excellency is on top of that in the sense that 2 of the amendments were simply deleting allegations. I mean, we wondered whether to wait until today to say they were deleted, and decided it would actually be more be fair to the other side and the court and save costs if we gave advance notice that we weren't going to be pressing those 2. Now that's being held against us as there's a reason for an adjournment. It's just absurd and impertinent. Those are just 2 deletions. We're dropping 2 charges. And as regards the point about the 20 million and 69 million, as it says in the notice says it's quoting something that Mr. Britton says in his asset list. We misquoted it. You just look at it and you can see it's just a typo. And that's why we had to change it. It was a typo. Obviously a typo if you take a look at the document that it's quoting. And of course, it was a mistake not to correct the typo in the next paragraph, again from 20 to 69 or vice versa. He's been having legal representation, certainly from Quinns, really for a long time, I think over a year, in this matter. Suddenly dropping the lawyers on the 7th of May after getting an amended committal application could just be a wheeze, actually. It's been done before. It's quite a neat one to say that if you're facing committal, that you can't get lawyers, because of course it immediately means that the judges have to suddenly have a heightened degree of awareness about fair trials. It's so I think that those are all the points I really wish to make. It's overall, this has to be seen against the background of obfuscation, of the criticisms that Your Excellency has made about this, about Mr. Britton's evidence before, which I don't think I need to remind Your Excellency of, about the evasiveness and about the lack of credibility. Everything about this since the service of the auditors has been about obfuscation, delay, evasion, and not saying what's happened to all this money. And we still don't know, despite our best efforts and despite this court's entirely appropriate strident orders, we still don't know. And now we're being asked on all these grounds again to say, well, don't make me say. Well, our submission is that justice will be served if we carry on. Justice will be denied if it's delayed any further. Unless I can assist further, Your Excellency.
No, thank you very much indeed. Before you start again, Mr. Yates, can I just inquire whether there is in fact a court reporter who needs a break at this stage?
Oh, God. Is that one?
There's no court report. No, it's done with AI or whatever. Okay, in which case, Mr. Yates, over to you.
Thank you. If I may, I'll address several of the points that honourable friend has made. The first was that there was a suggestion that there was an unwillingness on the part of the defendants to attend the committal hearing. There's no evidence of that. In fact, the direct evidence and my instructions are that there's a willingness, if particulars are finalised and the opportunity to have legal representation, it will be allowed. There is the second point, that a straw man argument has been raised effectively to the extent that these are things that the defendant could have done, not that they could have done had they wanted to. So they could have provided the ultimate source information, and that they could have given enhanced disclosure. But in this context, the contempt proceedings are not about what the defendant could have done. It's what he's been told to do, and whether or not he's done that. And so saying that there was opportunity to do, to provide that information, showing on the screen we still have the reference to the team that Mr. Britton supervised, and his ability, as it would seem there, to investigate across several jurisdictions. That's not the point, whether he can do it or whether he should do it. It's whether he's been told to do it, and he hasn't. Now, the other thing that...
Sorry, whether he's been told to do it, when you say whether he's been told to do it and he hasn't, you're flipping between the 17.2
and the substantive.
yes.
Your Honour, and that's the point that's my next point, that the claimants are conflating those. They're saying that there is already an outstanding obligation to provide these details, and that's why, in the context of the information about where his legal funding has come from, he must also provide those details. That is to conflate the two quite distinct issues. 17.2 is there as a protective mechanism, so that the subject of contempt, the contender, can obtain legal in the WFO, it's there to make sure they can have legal representation in the freezing order proceedings. In this context, it's here to ensure that the defendants can have representation in these contempt proceedings. The fact that there is an ancillary or an overriding objective or obligation, rather, to provide certain information, and whether or not that is being complied with is separately the subject of the committal application. So we can't visit the obligations due under the disclosure of information under the worldwide freezing order onto the 17.2 information provisions, because they are two-dimensional. In fact, in the case that Foxton, Justice Foxton as he then was dealing with, that was effectively a one-dimensional case, because what happened there is, well, two things are relevant. One, the original disclosure given was to say that the funds had come from the solicitor's account, and the judge said, well, that's useless, that's not the point, we need to know which account they come from. What the court refused to do in that case is to say that as well as where the funds have come from, you must tell us the amount. Because the judge said, no, that's not there. There is no provision for you to provide the amount. In that case, it was just the source of the funds. And that is...
But this case, in the present case, my order of the 30th of June says source and amount.
It does, Your Honour, and so in that respect, the judgment is still relevant, because what Justice Foxton said was you don't go beyond what was being ordered. So in this case, what Your Honour ordered was quite specific, and it did not involve any further disclosure beyond that point. So it's not a question of what the defendants could have done, it's what they were required to do, on whether or not they've done that.
So you agree? You agree with Mr. Pito that essentially one's not looking at the general rule, one is looking at my order of the 30th of June.
Right, yes.
Okay.
Now the third point, and I'm sure Mr. Beaver doesn't press it in quite the way it might have come across, but to say that the defendants, in this case, because of what they've done and against the background, that they don't deserve the adjournment, that is tricky ground, because...
He's not saying that they don't deserve the adjournment. What he's saying is that there is a pattern of conduct here which could suggest that this application for an adjournment is not brought in good faith.
Your Honour, if this was a situation where the final particularisation was some of the specifics of content was down to the defendant, that might be held against him. If his losing and his continuing inability to get legal representation was down to him, then again that would be something that the court might be mindful of. The last point that my own friend made was purely speculative, saying that, well, in some instances, contemners deliberately change lawyers so that they've got some reason to go to the court and say, well, I'll be prejudiced if I don't have legal representation. There's no evidence as to the circumstances in which Queen Emmanuel came off the record.
Well, there is evidence that your client owes them $1.6 million.
Well,
And he hasn't paid.
there's no evidence to say that it was a tactic on behalf of... no evidence to say that it was a tactic on behalf of the defendant. That was my point.
Well, no, and indeed Horizons came in.
Yes. So that was the third point. Now, you are expressed interest in, well, is this just another route to try and get disclosure? And we say that it is, and that's what this has always been. This is another route to try and get additional information as to where the funds are, but the interrogation of ultimate source, origin of legal funds, or funds for legal costs, is not the way to do it. It is through the obligation, well, the committal proceedings themselves are one tool that they can use to do that. If they are afraid that legal expenses are being paid out of a fund that, in the context of a proprietary injunction, is one that shouldn't be used, then their remedy lays elsewhere. They can apply to ring fence certain accounts. They can satisfy the test that's set out in G in relation to proprietary interests. And I have 3 copies of this, but I'm very sad that Mr. Peter isn't here, because I can't hand him one. But I can give you one of the reference. It's 21055. And I do have a copy for your Honour and for the other side.
Thank you very much.
So, Your Honour, this is their remedy. I'll try and speak slowly so that Mr. Peter can hear what I'm saying. The question is asked: what if there's a proprietary claim by the claimant? So the purpose of an injunction granted in aid of a proprietary claim is to stop the defendant expending for his own benefit what may be the claimant's property. No one has the right to use someone else's money to pay for their defence. And so before there can be any question of allowing the defendant to use funds to which the claimant has a very strong proprietary claim, he must show an arguable case for denying that they belong to the claimant. And then, where there are assets that may belong to the claimant, the court will not allow those funds to be used for legal costs until the defendant has shown by proper evidence, first, that he has no other assets. He has to use his own assets first. No other assets that could be used for this purpose. So if there are such funds, then the defendant must use these first before any question arises of his having access to funds which are the subject of a proprietary claim. Once it's shown that there are no other assets except those subject to the proprietary claim, the court must make a difficult decision in the exercise of its discretion as to what is to be done by considering where the balance of justice lies in permitting or refusing the payment. So if within the reasonable confines of an interrogatory application the claimant can demonstrate a strong probability that his proprietary claim to the assets is well founded, this must be taken into account in the court's decision whether, and if so on what terms, any variation is to be permitted. And then there are 4 questions. So does the claimant have an arguable proprietary claim to the funds in issue? If yes, does the defendant have arguable funds for denying that, arguable grounds for denying that claim? And then 3, if yes, has the defendant demonstrated that without the release of funds in issue, he cannot effectively defend the proceedings, or it may be added, meet his legitimate living expenses? And then 4, if yes, does the balance of justice lie as between, on the one hand, permitting the defendant to expend funds which might belong to the claimant, and on the other hand, refusing to allow the defendant to expend funds which might belong to it? The reason I've taken you to that, Your Honour, is that that is the remedy if the claimants believe that funds are proprietary. They attract a higher level of protection than the defendant's own funds, which have been frozen, but out of which he is allowed to spend a certain amount on legal expenses, so long as he says where they're coming from, and in this case how much he spent. That does not affect the disclosure obligation. That remains the same. There is no gloss that can be put on. Plain words, as found in Your Honour's order of the 30th of June and in 17.2. It gives a higher standard according to whether or not the funds are proprietary. There's no settled law on that position, and one can see why it doesn't work, because saying where the funds are coming from has a 2-dimensional element. It is not the starting point for a more investigative tracing action, which is something that would sit under the main freezing order, and which effectively has come to Your Honour now as an application. That's what the remedy application is. He hasn't done what he's supposed to, so we'd like you now to impose this higher obligation so that we can do some more digging and see where the money's gone. You don't put that in through the back door of the legal funding, disclosure obligations, or fiscal proviso, as it's termed. So that goes on to the question that Your Honour asked was, well, what's Horizon's position if the monies were traced back? What is Horizon's position? Well, the response you received was, well, it doesn't matter, they are exempt because you've effectively given absolution by saying that they won't be in a position to having received those funds pursuant to your order of the 30th of June. That's not the whole question. Again, it's avoiding what I've just taken you to, that if Horizons became aware, anybody became aware that these were proprietary funds, then they would have to be the subject of a separate application by the claimant, satisfying those 4 points as set out in G. And the court would then have to decide whether those funds could be used at all. So the difference between proprietary and non-proprietary is to do with the use to which the monies can be put. It's not to do with some higher level of disclosure. Your Honour, again, I'd ask you to take as nothing more than speculation the suggestion that if Your Honour were to grant an adjournment, then we'll just be back here in a couple of months in the same position with the same application being made. It's highly unlikely that I will be here in similar circumstances were that the case. But that would then not be the first application that had been made to adjourn these proceedings. Currently, this is. And it isn't satisfactory from a time, a court's time point of view. It isn't satisfactory, perhaps to the state of readiness that the claimant says it's at, but to allow the contempt proceedings, committal proceedings to continue today would, in the circumstances, taking into account everything that has been put forward on behalf of the defendant, it would be unfair and would be contrary to RDC 52. And on those grounds, I request Your Honour to allow the adjournment and allow the defendants to get representation and to be able to answer properly the charges that will be lodged against them in their final form, and effectively to reproduce the directions that were given on the 30th of May. That would be at least the framework, subject of course to provision of availability and any other ancillary issues that Your Honour may consider relevant in a case management hearing. Your Honour, those are my submissions on behalf of the defendants, unless I can assist you further in any particular point.
No, thank you very much. Mr. Pito, do you have access to G?
Yes, we've got. Yes, it's there, isn't it? Yeah. Yes, I do have the bit in front of me. I think that Leonard friend mentioned. So 21055 was it?
Yes, I think it's a new legal point, and I'd like to hear from you on it, please.
Sorry, can we just get?
Yeah,
just give me a moment.
Read through
Sorry,
it.
sorry.
Yes.
Yes. Yes, as I understand it, I wasn't. It's probably my fault. I didn't completely understand where the point was going to which this citation went. But the legal point seems to be, which is, I mean, it's new in the context of maybe this argument, but well established, is that where there's a proprietary claim, looks at the checklist, different considerations apply in the sense that if there's no defence to a proprietary claim, no arguable grounds for denying the claim, then defendant can't use the money which he may be in his hands to pay for his lawyers or anything else for that matter, if in fact that money is unarguably somebody else's. And so that defeats the argument straight away. So I guess what this is going to, it may be going to, here we would say there isn't an arguable defence in the, if there is money which is definitely coming from us, then there's no defence of a proprietary claim. At the moment, there's nothing before the court anyway which would amount to one, because as I understand it, there doesn't seem to be an arguable defence on the facts. However, of course, if it's money which doesn't derive from the 6 original payments, well, of course, then they can use that prima facie for their legal argument, for their legal expenses. The difficulty only arises where there's a possible arguable defence to the proprietary claim, which means the court is in a position where there's funds there that may very well belong to the claimant, but which might not. And if there's no other funds available, should they be used to fund a defence? But I guess that we don't get to that stage unless the court has got evidence in front of it which satisfies it that there's only allegedly proprietary funds which are available. And I guess our point would be here, arising from this, is that we don't have anything like that kind of evidence before the court, that there's non-proprietary funds available. There may be, because we haven't had proper disclosure of assets, we say, which of course would therefore levitate against permitting any of this money to be used. But maybe I'm missing something, but I don't. This point might go to whether Your Excellency should reconsider his order of the 30th of June about whether there should be this immunity.
I think the point that's made.
I don't think that's.
I think the point that's made, insofar as I understand it, is to say this is an illustration of the care with which the issue has to be considered, and you cannot simply say an order that says disclosing the source it necessitates a detailed analysis of the original derivation of the funds. I think that's what I understand the submission.
I see.
So it's saying that this is actually something that is open for you to do, and that you should be doing this if you're minded to do so, rather than simply saying that under 17.2 of the injunction, this sort of exercise is to be undertaken. It said that this should be a separate analysis.
Oh, I see. So it said that if I want to object to them using funds in one of those 2 named accounts,
Yes.
I should be making an application or an argument to show these funds are to make the arguments based on that checklist of 1 to 4.
Yeah.
So that and so this is effectively a dry procedural point. It's saying that what I should have done is bring an argument to say, look at these funds you want to use. Here's the evidence of why they're proprietary, and then go through 1, 2, 3, 4 and argue that if you haven't got a defence, so cadet quaestio, it means that you can't use them. Or if you do have a defence, is there any other money around which you could use? Have you satisfied the court that this is all you've got, is proprietary funds? And if the court is satisfied it's all you've got, then the court's got the balancing exercise. So it's saying that if it's saying, well, I should have brought an application to do that, go through that, rather than making an argument, rather than making the same points effectively, but making the points about a fund that they've identified they want to use. And I'm now objecting to them using it by saying you should be giving information sufficient for the court to be able to go through 1, 2, 3, and 4. I mean, if all they're saying is, well, if you'd made an application or raised it in some different way, then yes, we would have maybe had an obligation to go through 1, 2, 3, and 4 to justify us using the monies. Then fair enough. We should have done that. We should have given the information. But now that you're raising it in this way, by way of by saying that such a process is what is implicit in the court's order about identifying source, is so the judge can actually be informed about the information to go through 1, 2, 3, and 4. If all that's being said is that we've raised exactly the same points, but that way, then that's a completely arid point, devoid of merit. The important thing is that the judge needs to be in a position to go through points 1 to 4. And it's hard for us, we can't very easily, especially in the light of the non-disclosures we've been getting, we can't furnish that information for the judge to make that decision. But it is information which lies within the knowledge of the defence. And so it's reasonable, therefore, to be asking for that information, since prima facie, it's highly likely this money is proprietary because of the amounts that have gone into bio, which are admitted. And so they should provide the information to enable Your Excellency to go through that exercise. It's completely weird to be suggesting that somehow they're excused from that process, or that the court should be deprived of that benefit because of the way in which the point was raised. The point's been raised in correspondence as early as April. It's been live for a long time. They failed to meet it, and they're the only ones that know. So if it's a point about how it should be raised, there's nothing in that. But the law set out in 1 to 4 seems to be what the law is.
Yes.
And
actually, this seems rather more relevant to the remedy application, but we'll come to that in due course.
Well, except it's the same thing, really. I mean, if it has to be the same thing, doesn't it? Because although, I mean, we've got the point of interpretation that Your Excellency's order of the 30th of June is sui generis. It's a very unusual order immunising solicitors from suit to enable defence to happen. But given that that is such a is providing such an indulgence to the defence, I'm not saying that it's not an appropriate approach, but it's that therefore no, it's letting them off effectively. It's letting off solicitors, which is fair enough, they're officers of the court. Why it should let off the defendant from going through this 1 to 4 process, there's no reason why I should let him off that. None at all.
Well, you come back to the remedy application.
Well, except that's to do with a different order. That's the standard order. We're dealing with Your Excellency's order just for this.
I know, but
the order.
But the two roads lead to Rome.
True. They do, although I think there's one would argue that the need to have evidence to enable the court to go through 1 to 4 is all the more heightened by the fact that it comes as an entirely reasonable price to be paid for getting the huge benefit of Your Lordship's immunisation order. There's an even stronger reason for it. Even stronger. If you're going to take our money, possibly, to pay your own lawyers, and it turns out that you've been stealing our money to pay your lawyers for a defence which is entirely unmeritorious for contempt, then the court is exacting from you a very reasonable price, which is at least say where it's come from, so we can say if it's proprietary or not. Then we can go for remedies for that against you, rather than being able to just hide behind a veil. No, you're not going to know where this money's come from. It's proprietary. It's completely unfair. Now, in the context of 30th of June order, that is shown in that sharp relief. So the result of the interpretation of Your Excellency's bespoke order on the 30th of June may be different, may or may not be different from the interpretation of a standard order. But it is really a nerve. It is an impertinence, well, it's quite a lot to be saying, oh no, we're not going to tell you whether this is proprietary source or not. Oh, no, well, it might be a bit difficult for us to do it because we've stolen your money so effectively and mixed it up so effectively and invested so effectively, we can't say. That's not an argument either. Also, the argument is saying, well, you're trying to get by a different route what it was that the judge orders us to do by an ordinary route. No such thing. If the judge has ordered you to give certain information, you should give the information, and you haven't. If then in another context it arises that it would be unjust for the court to proceed without that information being given, it's fair enough to ask for that very same information to be given. And a bit weird to be told, no, you can't have it because it arises in a different context, when in fact the justice here really does require it. But it's, so to that extent, I suppose this analysis helps, because it shows what the approach should be when they are asking to use a particular fund. They're asking to use a particular fund, or I don't know whether there's money in that account now or not, or whether it's going to come from some other source, to say whether it's proprietary or not. And they're trying to say we don't have to say that. This, in fact, on reflection, is authoritative for saying that they should. The same principle applies. I don't. I'm happy to assist further if I can, but I don't know if I can.
No, thank you very much indeed. So let me tell you where I am at the moment. I am going to give an oral judgment on this application as quickly as I possibly can. It depends quite how long it'll take me. Certainly, I'm going to adjourn matters until 2 o'clock in the hope that I'll have finished my notes by then. That's 11 o'clock your time, Mr. Peter. I saw you looking at your watch. If I'm not finished by then the associate will inform you when I hope to be able to, but I will deliver the judgment today.
I may save you some time if you allow me 30 seconds to simplify what our argument is.
Okay.
It's this. The claimant says that there's a higher level of disclosure obligation because these may be proprietary funds, or this is a proprietary injunction. We say the proprietary or non-proprietary distinction doesn't go to a higher level of disclosure. It goes to whether or not the funds can be used. It's a use test. So when Your Honour said, or asked, well, what's the remedy? The remedy is for the claimant, if they believe they can, to make this type of application. We're not saying they should.
So you say make this type of application, but in fact the burden seems to be upon the defendant. So if you run through 1 to 4, does the claimant have an arguable proprietary claim to the funds in issue? Well, I've already found that. If yes, does the defendant have arguable grounds for denying the claim? I've already found that. There are serious issues to be tried on both sides. I stand back from the fact that I'm not the court charged with the actual determination of the substantive case. That is the Hong Kong court. So I found in a rather too long judgment that there were arguable issues on both sides. If yes, the defendant has demonstrated that without the release of funds in issue, he cannot effectively defend the proceedings. So the burden is then on the defendant to show that without the release of the funds, he cannot effectively defend the proceedings. I haven't seen anything along those lines.
Well, nobody is invoking this provision at the moment. Nobody is invoking this test. It's simply illustrative of what we say is a category error put on by the claimants as to the difference it makes as to whether it's proprietary or not. And the main point we make, let's forget about whether it's this 4-stage test. The point we make is that the language of 17.2 is the same whether it's proprietary or not. That's the point we make. We perhaps went down the rabbit hole to say, well, this in fact is how the court distinguishes. It's it's not when it comes to disclosure. It's not on the disclosure side. It's to do with the use side. It's just an illustration. We're not invoking it. We're not saying it's relevant here. We're just saying that this is the difference between a court dealing with proprietary injunctions and a standard freezing order. And in this case, there isn't any difference because the disclosure, the words in 17.2, the words of your order of the 30th of June are the same and mean the same regardless of whether it's proprietary or not.
Okay.
Thank you.
Right. Thank you very much for that. Okay, so I'm going to rise initially until 2 o'clock. As I said, if I need more time, council will be informed. Thank you very much.
All rise.
Sorry for the delay. I've been having some technical problems which have just come back again, which is slightly annoying. Sorry, technical problems mean that I might be a bit slow with some of my citations from the bundle. The bundle has been so big it's crashed and it's now corrupted, which is really annoying. Okay. I will do the best I can. Okay, I'll give my judgment now. This is an application on the part of the first and second defendants to adjourn the committal application listed to commence for a 5-day hearing. Given the urgency of the issues, I am giving a brief oral extempore judgment, but I reserve the opportunity to expand further on my reasons should it become necessary. The committal application was made as long ago as 16th March 2026. Meanwhile, on 14th April, Horizons and Co. had come on the record to represent the defendants for the purpose of seeking to adjourn the committal, and on 20th April I adjourned the hearing to 5th May and directed that any applications, including to strike out the committal, be filed by 30th April. There was correspondence between Altamimi and Company on behalf of the claimant and Horizons about proviso 17 brackets 2 close brackets to my original worldwide freezing order of 28th February 2025. Which was in standard form and read as follows: as an exception to the order, this order does not prohibit the first respondent from spending a reasonable sum on legal advice and representation. Before spending any money on legal advice and representation, the first respondent must tell the applicant's legal representatives where the money is to come from. On 29th April, Horizons wrote to Altamimi and Company they stated as follows: as a gesture of goodwill and without any obligation on the part of the first defendant, it is confirmed that this firm has received payments from 2 accounts. These are, and then a very long number. In the name of Aria Bio Industries FZE, we are informed by our client that this appears to be on the asset disclosure list at line 23. B, another identified account in the name of Aria Commodities FZCO, we are informed by our client that this account does not appear on the asset disclosure list. Whilst this firm was not aware of this, we are providing disclosure as soon as reasonably practicable after this information became apparent. In respect of the payment from the first respondent to FTI, those were experts that were instructed on behalf of the defendants. We are informed by our client that the amounts were settled by Aria Commodities USA LLC, brackets Bank of America, close brackets, and Aria Commodities FZCO. We are informed by our client that the bank account for Aria Commodities USA LLC is contained in the asset disclosure list at line 53. The account for Aria Commodities FZCO is as disclosed at paragraph 5b above. I pause to comment on this letter that I do not accept that there was no obligation on the part of the first defendant to disclose these bank accounts. It seems to me that there was every obligation under the terms of the freezing order to make that disclosure. I would also add that Aria Commodities FZCO appears to be the new name of the entity which was previously known as Aria Commodities Dmcc LLC, and it is the, excuse me one second, and is the first defendant in these proceedings. I had raised the possibility that the application did not comply with the provisions of the rules of the DIFC courts, brackets RDC, close brackets, part 52. While the claimant does not accept this is the case, on 30th April it served an amendment application annexing detailed particulars to the committal notice. On 5th May of 2026, I directed that by 4 p.m. on 12th May 2026, the respondents are to indicate if the amendment application is opposed and or whether any strikeout application is to be made in respect of it. By 4 p.m. on 25th May 2026, respondents to file and serve any evidence opposing the amendment application and or issue the strikeout application. By 4 p.m. on 1st June 2026, A, the claimant to file and serve any responsive evidence in the amendment application, B, the claimant to file and serve any evidence opposing the strikeout application, if made. By 4 p.m. 8th June 2026, the respondent to file and serve any responsive evidence in the strikeout application, if made. By 4 p.m. on 29th June 2026, respondents to file and serve any evidence relied on in opposition to the committal application, including any expert evidence verified by affidavit. By 4 p.m. 6th July 2026, claimant to file and serve any responsive evidence in the committal application verified by affidavit. By 4 p.m. 17th July, the claimant to file and serve its skeleton argument. By 4 p.m. 22nd July, the defendants to file and serve their skeleton argument. 10 a.m. on 27th July 2026, the final hearing to be listed for 5 days shall commence in person. On 6th May, Altamimi wrote to Horizons they said, there is no explanation of the amounts that have been paid to your firm or to FBI Consulting, nor how such amounts could have been paid from accounts which, according to the first respondent's asset disclosure list, held only de minimis balances. Line 23 of the assets disclosure list recorded funds just over $5,000 in respect of, and then the account number, held with ADIB in the name of Aria Bioindustries FZE, which has been identified in the letter as one of the two accounts from which your firm received payment. Line 53 of the asset disclosure list corresponding to the Aria Commodities USA LLC account, which is identified in the letter as alleged source of payments to FDI Consulting, recorded funds of approximately $3,600. Inadequate details have been provided regarding account number and then the number purportedly held in the name of Aria Commodities FZCO. The letter confirms that this account had not previously been disclosed in the first respondent's asset disclosure. No explanation has been provided for this non-disclosure, nor have any details been given as to where this account is located, the funds held in it, or the source of those funds. There is no explanation of the sources of the money in any of the accounts identified. The very low balances stated in the bank accounts at the asset disclosure list suggest that there is another undisclosed source of monies which has not been explained. In particular, information has been provided regarding the payment of £25,000 made to Quinn Emanuel on $25,000 made to Quinn Emanuel on 27th April 2026, which has since come to light. The payment and the source of funds were not disclosed to the claimant in the letter or otherwise in breach of the order. In the circumstances, we repeat the requests in our letter dated 20th April, which remain outstanding and must be responded in full. Please provide by return the following information in respect of all payments made by your client for legal advice and representation, including to your own firm, FTI Consulting and or Quinn Emanuel. A1, little Roman 1 in brackets, the amount that has been paid. 2, the dates of such payment. 3, details of bank accounts from which the monies were paid. And 4, a full and proper explanation of the source of these payments. Given the very low balances in the accounts referred to, your clients should fully explain the original sources of any further monies which have been paid into those accounts or otherwise paid to lawyers, which should include an explanation of how those accounts were funded, in what amounts, when and from what sources these monies were paid to the respondent's lawyers, ultimately derived. In response to this, on the 8th of May, Horizons and Company came off the record. They say that they were concerned about becoming constructive trustees of any sums received by them in respect of legal fees in the light of an email from Altamimi and Company dated 13th April 2026. Applications were made by the defendants on 1st and 17th June, in consequence of which I made an order on 30th June in the following terms. Paragraph 4, heading the 1st June 2026 and the 17th June 2026 application. A. Horizons & Co. Law Firm LLC and Counsel, or such other representatives as may be instructed by the first and second respondents in these proceedings, are at liberty to resume, continue, or commence acting for the first and second respondents in these proceedings. B. Horizons and Company Law Firm LLC and Counsel, or such other legal representatives may be instructed, shall not, by reason of resuming, continuing, or commencing to act, or by reason of receiving or holding funds paid as legal fees from account, and then the number is given, in the name of Aria Bioindustries FZE, and account, again number given, in the name of Aria Commodities FZCO, be in contempt of paragraph 17.2 of the worldwide freezing order, or incur liability as constructive trustees to the claimant in respect of such funds, provided, bold, italic, underlined, that before spending any money on legal advice and representation, the first respondent and second respondent must inform the claimant's legal representatives, little Roman 1, the amount to be spent, and little Roman 2, the source of the funds. Unfortunately, this did not clear the way for Horizons to resume acting. On 6 July, Horizons wrote to Altamimi and Company, paragraph 4, whilst the obligations set out at paragraph 4b of the order fall upon the first and second defendants, as this firm is named in the order, we note as follows. A, the Claimant's Counsel is aware in dealing with paragraph 4b2 of the order, this firm satisfied its obligations regarding the identification of the source of funds received in settlement of and or held on account in respect of its legal fees and those of counsel by way of its letters dated 17th and 29th April 26. In respect of paragraph 4b1 of the order, this firm can confirm the amounts currently held on account of fees as follows. And the source is Aria Bioindustries FZE, gives the account number, the date of 14th April 2026, and the amount of 619,801 dirhams and 88 fils. This firm considers the obligations pursuant to the order in respect of historic payments to be discharged. On that basis, this firm will release monies it holds on account to settle its own fees and those of counsel within 24 hours of the date of this letter. The following day, 7th of July, Altamimi wrote as follows. Specifically, it is not sufficient only to identify the source of funds as being Aria Bioindustries FZE without further explanation. Mr. Britton admits that funds that were misappropriated from the claimant have been paid to Aria Bioindustries FZE. Paragraph 4b2 of the order, like paragraph 17.2 of the worldwide freezing order, requires the first and second respondents to explain the original sources of monies which are proposed to be used for legal expenses, and which should include an explanation of how the bank accounts were funded, in what amounts, when, and from what sources these monies are ultimately derived. Your letter is wrong to state that the obligations in respect of historic payments are discharged. Your letter does not include any further information about the sources of the funds and is plainly inadequate in those circumstances where the condition of subparagraph little Roman 2 has not been met and paragraph 4b of the order does not apply. Counsel for, on 17th July 2026, the claimant amended the particulars of contempt further in order to correct a typographical error and remove some of the allegations. Counsel for both parties agree that the obligation with regard to the sources of funds for legal expenses is now to be found in my order of 30th June, which counsel for the claimant, Mr. Pito of King's Counsel, described as a, quotes, bespoke order, unquotes. In my judgment, an objective reading of the order permits Horizon to receive from one or both of two identified accounts, provided that the amount is disclosed and the source is identified. In the context of the order, the quotes, source, unquotes, must mean which account. I accept Mr. Pito's submission that when one is considering the general form of order, especially in a proprietary injunction case, it is necessary to understand whether the funds being used to discharge legal costs are monies that may arguably belong to the applicant. Indeed, Mr. Yates, for the defendant, cited a passage from G on Commercial Injunction 7th edition at paragraph 21-055. I'm sorry, I left my copy. Can I have another copy, please, if it's unmarked? That's great, thank you. Quote, what if there is a proprietary claim by the claimant, question mark. The purpose of an injunction granted in aid of a proprietary claim is to stop the defendant expending for his own benefit what may be the claimant's property. No one has the right to use someone else's money to pay for their defence. So before there can be any question of allowing a defendant to use funds to which the claimant has a very strong proprietary claim, he must show an arguable case for denying that they belong to the claimant. I'll skip the quote that's authority for that. Where there are assets which may belong to the claimant, the court will not allow those funds to be used for legal costs until the defendant has shown by quotes proper evidence, unquotes, that he has no other assets which can be used for this purpose. If there are such funds, then the defendant must use these before any question arises of his having access to funds which are the subject of a proprietary claim. But once it is shown that there are no other assets except those subject to a proprietary claim, the court must make a difficult decision in the exercise of its discretion as to what is to be done by considering where the balance of justice lies in permitting or refusing payment. If when the reasonable confines of an interlocutory application, if within the reasonable confines of interlocutory application the claimant can demonstrate a strong probability that his proprietary claim to the assets is well founded, this must be taken into account in the court's decision, whether and if so, what terms any variation is to be permitted. There are four questions. 1, does the claimant have an arguable proprietary claim in the funds in issue? 2, if yes, does the defendant have arguable grounds for denying that claim? 3, if yes, has the defendant demonstrated that without release of the funds in issue he cannot effectively defend the proceedings, brackets, or it may be added, meet his legitimate living expenses, close brackets. 4, if yes, where does the balance of justice lie between, on the one hand, permitting the defendant to expend funds which might belong to a claimant, and on the other hand, refusing to allow the defendant to expend funds which might belong to it? However, the function of the 30th June order is different from the standard form order that is there being considered by Mr. G in his book and set out at paragraph 17.2 of the Worldwide Freezing Order. The 30th of June order absolves Horizons from liability if sums come from the identified accounts. It does not, in my judgment, mandate any further inquiries. At this stage, I will not comment, however, on what obligations to make disclosures may arise more generally under paragraph 17.2 of the Worldwide Freezing Order and the considerations set out by Mr. G. It follows that I consider that Horizons have discharged the defendant's obligations under the 30th of June order and were therefore justified in remaining off the record in the face of concerns that they may be threatened with contempt proceedings as constructive trustees of the monies which are said ultimately to derive from the 6 remittances of the claimant sums which found their way to the defendants. The effect of this is that the defendants have been unrepresented in the run-up to the contempt hearing. Mr. Yates, who appears unpaid solely for the purpose of seeking the adjournment, contends that there are two grounds why there should be an adjournment. One, the defendants are unrepresented, and two, the particulars of contempt are not yet finalised. Only recently, this court issued practice direction number 1 of 2026 dealing with adjournments of trials, and I would say that the same principles must apply to this hearing. At paragraph 2.3, the practice direction states that parties must continue to prepare for any listed hearing unless and until the court has ordered or directed that the hearing be adjourned, vacated, or otherwise varied. At paragraph 4.3 of the practice direction, it is stated the application shall explain A, the reasons for the adjournment sought, B, when those reasons arose, and C, any prejudice said to result if the adjournment is not granted. I would also make reference to RDC 26.85, which provides that the court will not allow a failure to comply with directions to lead to the postponement of the trial unless the circumstances are exceptional. Mr. Yates has very helpfully and objectively set out the general principles governing adjournments in his skeleton argument. And indeed, Mr. Peto was content to adopt his summary at paragraphs 3.3 to 3.5. In which he states, paragraph 3.3, the court approaches an application to adjourn with a considerable degree of caution and will only contemplate an adjournment if it is, quote, really necessary to achieve justice between the parties, unquote, Corinth Pipeworks SA against Barclays Bank PLC, v brackets 1 close brackets Afras Limited brackets 2 close brackets Radha Krishnan Nanda Kumar 2010 DIFC CFI 024 brackets Steel J close brackets at paragraphs 9, 27 to 28, and 30. This is reinforced by RDC 26.89 to 26.91, under which postponement of a trial is an order of last resort and the court will not postpone without a very good reason. 3.4, where an adjournment is sought at a late stage of civil proceedings, the court has required the applicant to demonstrate a defence with a realistic prospect of success. The same test applicable to an application for immediate judgment under RDC 24.1. Transasia Private Capital Limited against Mados Trading 2021 DIFC CFI 079 at paragraphs 44 to 46. In formulating that test, the court in Transasia distinguished Al Rehab against Emirates NBD Bank 2020 DIFC CA 006 at paragraph 125, in which the Court of Appeal on the facts before it noted only the absence of, quote, any possible line of defence, unquote, without purporting to lay down a general test. The merits-based test has no application here. It was developed for and is calibrated to applications to adjourn a hearing of a civil claim on the merits, where, brackets, as Transasia itself recognised at paragraph 45, close brackets, the adjournment application, open brackets, open inverted commas, merges with, close inverted commas, the application for judgment of the underlying claim. The adjournment application does not concern the merits of any defence. To the committal application, it concerns the first and second defendant's ability to be represented to prepare for a quasi-criminal committal application in circumstances where their right to legal advice and to adequate time to prepare are independently under RDC 5220 to 21 as addressed in section 4 below. 3.5, the court has adopted a multi-factor checklist relevant to whether it should proceed in a party's absence to grant an adjournment. Excel Insurance Company SE v. IPORS Underwriting Limited, brackets 2021, close brackets EWHC 1407, brackets com, close brackets, paragraphs 45 to 46, adopting the checklist in Sanchez v. Abos 2015 EWHC 235, brackets FAM, close brackets. Both are decisions of the English courts. The DIFC rules set out the court's general discretion to proceed in a party's absence at RDC 23.85 to 23.87 without prescribing a structured checklist for its exercise. The DIFC courts have shown a willingness to draw on English case law for the interpretive guidance in analogous procedural gaps. The factors are: 1, whether the party has been served with the relevant documents, including notice of hearing; 2, whether the party has had sufficient notice to prepare for the hearing; 3, the reason for absence of non-readiness; 4, whether the party knew of or was indifferent to the consequences of proceeding in its absence; 5, whether an adjournment would be likely to secure attendance or facilitate representation; 6, the extent of disadvantage to the party in not being able to present its case; 7, whether the undue prejudice would be caused to whether undue prejudice would be caused to the other party by delay; 8, whether undue prejudice would be caused to the forensic process; and 9, the overriding objective. If I may just comment on particularly the question of adjournment of a trial at a late date and the need to show a good defense. I do consider that the situation is different in relation to committal proceedings, where a respondent has a right of silence and indeed is entitled simply to say to the applicant, prove it, rather than make a substantive defense. Mr. Pito submitted with his characteristic bluntness that the defendants are, I quote, brackets, are indulging in, I quote, just a wheeze and quite a neat one, playing on the judges, unquote, playing on the judges' heightened awareness of the need for a fair trial set out in RDC 52. RDC 52 provides at 5220 Sorry, my bundle is corrupted again. Try again. In dealing with any committal application, the court will have regard to the need for the respondent to have details of the alleged acts of contempt and the opportunity to respond to the committal application. At 5221, it is provided that the court should also have regard to the need for the respondent to be, 1, allowed a reasonable time for responding to the committal application, including, if necessary, preparing a defence, 2, given the opportunity, if unrepresented, to obtain legal advice, and 3, if unable to understand English, allowed to make arrangements seeking the assistance of the court, if necessary, for an interpreter to attend the hearing. 3 obviously doesn't apply in present circumstances. Mr. Pito emphasised that all of this is against a background of previous criticisms of the defendants for evasiveness, obfuscation and delay. I am quite aware of what has gone before, and of course the observations I have made more than once. I do not rule out the possibility that the present situation has been engineered in the manner suggested by Mr. Pito. The dilemma for the court is that there are numerous jurisdictions in play in this matter. While I can be reasonably sure about the attitude that the DIFC Court of Appeal may adopt in relation to any orders I may make, I entertain some doubts as to the approach of other courts, especially when filtered through the submissions of counsel not directly involved in these proceedings. This accentuates and gives context to the primary consideration. In a procedure that may ultimately lead to the imprisonment of the human defendant and the seizure of the assets of the corporate defendant, every effort must be made to ensure fairness and observation of due process. It is therefore not without some considerable reservations that I am of the view that the most prudent course is to adjourn the committal hearing, but on fairly strict terms, essentially giving the defendants one last chance to demonstrate their bona fides. So, Mr. Yates and Mr. Peter, I'd like to discuss, if I may, directions. Can I tell you, Mr. Yates, there is no chance whatsoever that you will persuade me to adjourn this matter without the consent of the claimant for a period of 11 weeks or more.
Your Honour, we should hear from Mr. Pito on that.
Well, let me just tell you actually what my availability is, and my preferred date, if I may. Let me just find my notes on that. I do apologise about the clunkiness of that judgment. As I say, I had bundle problems. So, in terms of my availability, I can do the week commencing 31st August 2026, which is actually a period of 6 weeks. Now, I put Mr. Pito to his election. I'm not going to give you a choice on this, Mr. Yates. The alternative to that, the earliest alternative to that, would be the week commencing 5th October 26. Those are my availabilities. I recognise 31st August may generally not be an attractive date. But I consider 6 weeks to be more than adequate for the defendants.
So, you're actually, can I just check a couple of things and take some instructions?
Of course you can, yes. week commencing 5th October. Okay, well, we'll just see. Well, we may actually be in London. They won't suggest. So we'll get to that. Thank you very much.
Probably on the camera. I'm terribly sorry to be taking up time on this, Your Excellency. Would it be okay just to have a 10-minute adjournment while we come back with that election? I'm sorry.
Yes, well,
just think we have
actually,
to...
the other thing we can consider is venue. You.
Why I stood up, Your Honour. I was going to say we're open to that.
Yes, you're instructing legal representatives floated the possibility of a hearing in London, and particularly in the light of Mr. Britton's evidence that he has to remain in London to care for members of his family. Maybe that would be appropriate on both sides. So would you also take instructions on that?
Understood. We'll do that as well, Your Excellency. Thank you. So those are the two things, I guess. Right. I guess after we've got venue and we've got time and place to order that, then the other directions can follow from that, I suppose.
Yes,
so we'll be
let me
okay
just, while you're taking instructions, let me just tell you the way my mind is working. Of course, Mr. Yates drops out of the picture after this, but the next steps, I will go on to consider the amendment application and deal with it today, if there's enough time, if not tomorrow morning. And I will also deal with the remedy application either today or tomorrow morning. Mr. Britton will have to represent himself on that.
Understood. But amendment application, yes, Your Excellency. The remedy application, I guess tomorrow morning. I wanted to digest a bit Your Excellency's observations and the judgment now before coming back to that. Which is the reason why
we can deal with that tomorrow, if you wish. It would be helpful to deal with the remedy application today.
Yeah.
because it will also affect the directions in relation to the in relation to the hearing.
Right, I understand. Yes, so I see that. We could have 10 minutes just for the moment.
Yes, of
if
course.
That's all right.
Yes, well,
Thanks so much.
it is now 35 minutes past 3. We'll come back then at 3:45 Dubai time. Yeah.
Well obliged, Lord. Thank you, Your Excellency. Thank you.
All rise.
Your Excellency, thanks very much indeed for that time to consider things. Where we are is we are content to accede to Your Excellency's invitation to go for the first week of September, I'll call it, although I think the first day is the 31st of August.
Yes.
So that's the quickest available. The second point that was raised about venue, we would also respectfully agree with the suggestion that it would make sense to have it in London, since Mr. Britton is here, and the direction was he should attend. And so, subject, of course, to Your Excellency, we could make arrangements for a suitable venue here. And that does seem to make sense in the committal that one should have the presence of the defendant, and it wouldn't then get in the way of his care obligations. So those are the 2 points I think that.
Yes. Can I just check with Mr. Yates about London? About London.
So
How's that? Is that better?
yes, much better. Thank you.
Better, thank you. It shouldn't be a factor. We would ask for London. Whoever counsel may be, he'll have to find somebody, whether it's original Sting or somebody else.
But yes, I mean, yeah, obviously, counsel's one matter, but you've presumably taken instructions from your client.
Yes.
And your client is content for London.
Your Honour, yes.
Yes. Okay. So it will be London, and the claimant will make arrangements for a suitable venue somewhere like the IDRC, for example, might be appropriate.
We will make inquiries and make proposals, Your Excellency.
Okay. We then get to directions. Obviously, you're not instructed, Mr. Yates, on any of this, but feel free to chip in if you wish. But and particularly if you're in touch with Mr. Britton, who can either speak through you or for himself. It's up to him.
Yes. Well, Your Honour, it doesn't quite allow the same amount of time to
I'm
take us.
fully aware of that.
But if it could contain the same elements in an abbreviated form, that might be a starting point to the extent we need them.
Yes. So, do you said some of the elements? Do you wish to make some proposal, or?
Your Honour, I'd have to remind myself of them, but I am.
Well,
I have to
there
remind
is.
myself as to whether they touch upon anything that the remedy application and the amendment application will deal with.
Well, let's assume, for the purposes of argument only, that I grant the amendment application. The defendants will have to file evidence if they wish in response to that, so there'll have to be time for that. I am of the view that the time for the strikeout is long past.
Yeah.
It may not be something that is as attractive if the amendment is in the format of
Yes.
the amended.
So I think that's gone in any event, frankly, on the timetable. So it's really just a matter of timing to file evidence and then evidence in reply. If we have 8 weeks to play with, we could.
What was that?
We could do.
I think it's 5 weeks.
Is it 5 weeks? Have I
We're
miscounted?
With the
the
27th
27th
now,
of July today.
Yes, you're
4 weeks.
1, 2, 3, 4. Yes, 5 weeks. You're absolutely right. So, shall we say something like 2 weeks for the respondents to file their evidence, and then can you respond to that in a week, you think?
I think I'm told we can.
So that we could do 2 weeks plus 1 week, and then skeletons a week before. Well, you have
Yes.
yes.
We've done the skeletons, but amended skeletons. Well, sorry, defence haven't got one, but yes, we might just submit a supplemental skeleton, I guess, if it has to deal with any new matters.
Yes. Again, Mr. Yates, as amicus, do you have any comments on that?
Your Honour, no, was that week 4? So that was a further week beyond the
Yes. So week 4 would be.
claimant's response.
So it would be 2. Week 2 would be the defendant's evidence. Week 3 would be evidence in reply, and then week 4 would be skeletons, which gives everybody time to prepare for week 5.
Yes, Your Honour, that's a clear week before that
Okay.
week of the hearing.
Your Honour, sorry. If that's the timetable,
Yeah.
I think that's everything on the timetable. Just one direction I'd ask for, which I apprehend has become common in England, which is this: it's to square the circle of preserving the right of silence at the same time as preventing ambush.
I know what you're going to ask, and I have thought about it. And it seems to me that it's the exclusion of the evidence on Justice Martin's decision in Latif was a matter for the hearing, wasn't it? He dealt with it in that way. Rather than anticipating it, he decided that it was appropriate at that time to decide whether or not to admit it at the hearing.
Well, it seems that what the directions I had in mind, I'm not sure whether that's the same point or not, but it was that
It's the point that if they will not be cross-examined, then the evidence is excluded. That's where you're going, isn't it?
Well, it's like, yes, but it comes like this, that there's a direction for Mr. Britton or the company to put in their defence evidence by a certain time. However, it doesn't get filed at court, and it's under an embargo. We can see it, so that then we can prepare to deal with it and to cross-examine on it if there's going to be cross-examination at the trial. But it preserves the defendant's right at trial to make an election not to give evidence at all, to exercise his right of silence then, in which case the witness statement doesn't ever see the light of day, and the court doesn't see it. But it means that if he does elect to give evidence that day, and the normal rule is that if he does give evidence, he is cross-examined, this idea that there's being a discretion to disallow it is novel and not really, it's not something normal in English common law trials to allow people to do that. If he elects to put it in, then he can be subject to cross-examination on the day. But also we then know what's going in, so we can deal with it by way of submissions, even if we're not cross-examining, rather than having the ambush of oral evidence given on the day of the trial without any foreshadowing of what it is, without any ability for us to prepare to deal with it. So this regime preserves the right of silence entirely. So on the day of trial, he can decide not to give evidence. But if he does, we've got at least if he does so, then the witness statement then becomes admissible, and we've had a chance to prepare for it.
But there's also a provision in Part 52 whereby a respondent can give evidence whether or not the respondent serves evidence, written evidence.
Well, that's right. He has a right. If there's no direction, if there's no direction to do that, then of course he can do that. That preserves that right. He can give oral evidence, and so he could give oral evidence. He could give evidence in chief, I suppose, on the day of the trial, which wouldn't be the same. It wouldn't just be swearing to his witness statement.
No.
It preserves that. But if we have his witness statement in advance, then we've actually got a. I see where you're coming from. So you're thinking, what happens if we just get a two-pager, which says nothing very much? He gives all his first evidence at trial.
Well, I was
but that
also
wouldn't be
meeting a
fair.
question about. I was also trying to just understand your point about ambush.
Well, the point about ambush is that, years ago, of course, in common law, and I'm old enough when I started at the bar, there weren't any such things as witness statements. And so a witness arrived, gave his oral evidence in chief, and you had to deal with it as best you could.
Well,
which is trial by ambush.
I suspect I'm older than you. I certainly
I remember that too. But then we changed all that by having witness evidence being served so that one would be able to prepare. But if you decided not to call your witness on the day, then that wouldn't normally become admissible. So that being the regime now in common law civil trials, the practice seems to have risen in committal, where of course different considerations apply, where we can have our cake and eat it. We can have advance notice of what the evidence in chief is going to be by way of a witness statement, but that doesn't get deployed or used if on the day the respondent chooses to exercise his right of silence and not give evidence. But if he does, then that should stand as evidence in chief.
Yes,
it doesn't stop.
It seems to me.
Yes.
It seems to me that the object of that exercise is that the judge doesn't see the witness statement unless the respondent exposes themselves to cross-examination.
Yes, that's right.
It does seem a bit of an unnecessary elaboration to me.
But the necessity of it.
Capable of not referring to a witness statement if it's excluded.
I see. So I see. Well, it's more a question of fairness to the claimant, though.
Well, I'm not sure it is. I'm not sure it's fairness to the claimant either. As I said, the claimant can choose to give evidence without a witness statement. If he puts a witness statement in but chooses not to be cross-examined, then that's his choice and that evidence is excluded. So he either chooses to put a witness statement in or not, as the case may be, knowing that the court has a discretion, which it may or may not exercise at the hearing, to exclude the evidence. I have to say I find the Chief Justice's analysis quite sensible, with respect. That
and that analysis being sorry.
So that there is a discretion in the court to exclude the evidence, but the discretion remains with the judge.
You mean that's if, in fact, a witness statement has been served?
If a witness statement has been served, but the deponent does not expose themselves to cross-examination, then
I see.
there's a discretion to exclude the evidence. That seems the most flexible and sensible approach to me. It's not binding upon me. The Chief Justice gave this guidance when he was sitting at first instance, but it does seem sensible. And I have followed it in another case.
Well, I think I'm making a slightly different point, which is about the point about not being ambushed. I
don't think you can avoid ambush in a sense if it's open to a respondent not to serve and still give evidence. That's what I was referring to a moment ago. There's a right there in part 52.
There's a right there. It's okay. I can't take away from 52.14, and I suspect actually a common law one couldn't either.
No.
But analogously, I suppose, to other jurisdictions is the ability to comment. There can be a direction saying that one could say, I suppose, that he's at liberty to put in a witness statement. If he's intending to give evidence, to put in a witness statement containing the substance of what he intends to give. And if he doesn't avail himself of that possibility, and that witness statement then being protected in the way I suggest, that means that he elects his right of silence and it's excluded. But that means then that if he departs from that witness statement, that can be a subject of comment. Why didn't you do that before? And that is not inconsistent with, as I understand it, the kind of practice that now pertains in some criminal courts in this country, although I'm not a practitioner in those courts. But that seems to be fair. One's allowed to draw an inference anyway from the election to exercise the right of silence. Whether that's fair or not, but that's now the law. One can draw that adverse inference where the court thinks it's appropriate. It seems that it's only fair for the claimant, at least, to have a position where, if it's desired to put in oral evidence of any substance, that we get to see, subject to an embargo, that substance in advance so we can prepare and also have an idea whether we've got to reply to it.
Yeah, I mean, I don't see the issue on an embargo. I mean, the only justification I can see for an embargo, which seems to be over elaborate, is to protect the judge from seeing it. It doesn't actually protect either party.
Well, it protects the defendant from a judge seeing evidence which then otherwise the judge has to put out of his or her mind.
But that's the respondent's choice.
Okay, but I think what I'm asking for, maybe that the embargo I don't press necessarily, that's a defence point.
I think it's over elaborate. I mean, it seems to me that the straightforward position is what the court makes provision for the finding of evidence. It's up to the respondent whether he chooses or not to file evidence. If he files evidence but declines to be cross-examined, there is a discretion in the court to exclude that evidence entirely. If he doesn't file evidence but chooses to give, doesn't file written evidence but chooses to give oral evidence, then he can be cross-examined on that. That's 5214. I mean, it all seems rather straightforward.
Well, yes. I mean, as regards the putting in written evidence and declining to be cross-examined on it, surely the court does have a discretion to order him to be cross-examined on it.
I know.
He can argue.
The sanction, you can't order somebody to give evidence in their own defence to a quasi-criminal charge. I mean, that is a breach of the right of silence. What you do is exclude the evidence.
Or yes, we'll exclude the evidence. Yes,
so it's
indeed,
it's uncontested.
Yes, so it would then be excluded unless he tenders himself for cross-examination.
Exactly.
Well, look, what I'm trying to avoid is suddenly being faced with a lot of oral evidence on the day which I haven't had advance notice of.
You can't avoid that. That's 5214. But then you get the chance to cross-examine.
I do. I can't avoid that, but I can. If there's a direction that he should put in witness evidence, if he's intending to give oral evidence,
I cannot put a direction in compelling a respondent to a committal to give evidence.
No, I know that. It's the direction should be though that
if he chooses,
that
if the defendants choose to put evidence in, they will put it in by that date. And it's in the knowledge that if they don't put it in, they can still give oral evidence, but they will be cross-examined. What they can't do is put in written evidence and not be cross-examined, essentially.
they can't do. Well, sorry, this is a longer discussion. I'm trying to find a solution whereby there's a way without invading the right of silence that we can have fair notice of what's expected to be given orally.
Well, I think it's very straightforward, and I don't think I can order any more than this is the date by which you file written evidence. There's then a discretion to exclude that evidence if the deponent is not willing to be cross-examined. On the other hand, RDC 5214, which is an English provision, as you say, probably reflects the underlying common law in any event, says the respondent may give evidence at the hearing whether or not he has filed or served any written evidence. It's very clear. If he does so, he may be cross-examined. There's no way out. There's no
Very
way
well
around
then.
that.
However, I wouldn't. It would be helpful to have it recorded, though, that if there's going to be oral evidence given for the first time at the hearing, when there was an opportunity to foreshadow it by a witness statement earlier, and it hasn't been, that that we may draw inferences.
Well, one can always draw any inference. I mean, I think that's the province of the judge on assessing the evidence.
Well, the point is that a submission can be made.
You can
for an
make,
inference
yes.
to be drawn.
I don't think it's necessary to put it in any order. I mean, that is, that's part of the job of the judge, isn't it?
Well, I mean, it's yes. Well, I mean, at common law, of course, you had a right of silence in criminal cases. You didn't have to answer police questions or give evidence in court, and there was a positive law that you couldn't draw an inference against a man for referring to not doing that. Then the law changed to actually positively say that inferences could be drawn, and a judge could direct the fact finder to draw inferences if they thought it was appropriate. So it's just a warning there, I suppose.
No,
in this
it's
case,
it's in the skeleton arguments. There's a decision, I think, of His Excellency Justice Al-Madani, who drew inferences.
okay. Well, I'll stop there. And I'm grateful to Your Excellency for his patience.
Of action, yes.
Your Honour, do you need to hear me on that?
Yeah, Mr. Yates, if there's anything you want to add.
No, Your Honour, it's just that would attempt a restriction or fettering of the 5214 right. What's effectively being sought is an idea that unless you put in some kind of notice that we won't show anybody and telling us what you're going to say, then you can't say anything. So that would go directly against 5214. In the alternative, to say that if you fail to provide something beforehand, then that's the equivalent of you do not have to say anything, but if you fail to mention something now that you later rely on in court, then the inferences can be drawn. That's the direct analogy. They're trying to say if you bring something up for the first time, then it might be held against you that you're only raising it now. And that is disguised as we don't want to be ambushed. But unfortunately, that's what the rules provide. The protection is balanced. It's that the respondent always has the right to give oral evidence, and the balance is that they can be cross-examined if they do so.
Yes. Yes, I mean...
And we can comment if it's a news story which they could have given earlier.
Of course you can, and then that's a matter purely for the judge on the judge's findings of fact. So I think we leave it open and flexible. Thank you very much. Then there comes a question of costs. Of today's outing.
And my submission would be these should be costs in the application.
Costs in the committal.
Yes, that's what I meant. Costs in the committal. At the moment, the court is going to be finding on the merits of the committal application at the end of this trial. Then it will be, having heard the evidence and having heard maybe also from Mr. Britton, or maybe not, in a good position to know whether, in fact, this application for adjournment was meritorious or not.
Yes.
But also, if it's costs in the committal, if this man is actually found guilty of the contempts which he's accused of, which is hiding the best part of $500 million in breaches of orders, then he's got no merit at all in having any costs going his way. If we lose, and we don't manage to establish that, well, then fair enough.
Yes.
Then he gets them. I mean, absolutely.
That seems to be realistic. Mr. Yates.
Your Honour, the only thing that bites against that is the idea that the reason why the main reason why the adjournment has been occasioned is because the defendants lost their legal representation. And the cause of that, the direct cause of that, is the requests that were made from the claimant's lawyers asking for things. And that's the cause. That is the real reason why it didn't go ahead today.
I know that's your submission. I'm not 100% with you on that. I have some doubts, as I expressed in my extempore judgment. I think those doubts will be resolved by the end of these proceedings, one way or the other.
Your Honour, would you reserve them in that
Yes,
case?
yes.
And not put them in the case, in which case Your Honour will be better informed of future events. And you'd be able to make it in hindsight.
I'm happy to reserve it. Honestly, it's half a dozen of one and six of the other, as far as I can see.
Okay. Yeah, well, cost reserved, yes, Your Excellency. However, what costs? We've been told time and time again that the lawyers today have acted and 3 cheers for them pro bono. So, yeah, by all means, reserve the non-costs for the 0 that will be claimed. Where are they to get them?
That's
I want to record
that's assuming the respondent's costs, and I understand that you have some, which you may wish to recover.
Oh yes, we may, but it's because we're not appearing pro bono. But since my learned friend is, and I repeat,
That's a matter for the assessment, not for the question
yes.
of whether it's reserved or not.
No. Okay, so well, cost reserved then, I guess.
Okay. Anything else on the adjournment application?
No,
I think that's it. We will be in touch about venue, about arrangements.
Yes. Mr. Yates, anything?
no, Your Honour, thank you.
Okay, well, you're free to go or stay as you please now. I'm going to deal with the amendment application.
Thank you, Your Honour. I try to make as little disturbance as possible, but I would like to avoid the parking. It's not exactly free. I'm paying to attend because of the DIFC parking charges, so I'll try and put a stop to those as soon as I can.
That's up to you. It's a public hearing. You're quite welcome to stay.
Thank you, Your Honour.
So, we're going to move on to the amendment application.
Yes.
Is Mr. Britton online?
I am, Your Excellency.
Okay, and you're going to represent yourself on this then?
Well, to my very limited ability.
Okay, I think you're possibly being unduly modest having read your witness statements, but there we go. Okay, Mr. Pito is then going to make the application, and I'll give you an opportunity to comment upon it.
Thank you, Your Excellency.
Well, Your Excellency, the principles will be well known to Your Excellency. They are set out in paragraphs 14 to 15 of our skeleton. I don't think I need rehearse those. Our primary contention is, of course, that our original application plus the supporting affidavit was adequate, but out of an abundance of caution, we made this application to amend to improve the particularizations of the allegations in question. And the reference there's the Deutsche Bank case, which we referred to in our skeleton at paragraph 15.3.
Can you give me a bundle reference to your skeleton?
Sorry, yes, I do beg your pardon.
So the skeleton element is at 14846, but I need to get the page.
The beginning of the skeleton is 14846. Sorry about this, but the paragraph within it, which is a paragraph 15.3, is 10 pages into the skeleton, so it must be 10 pages after that.
It's 1484 then. 14854, sorry, if Mr. Britton is following.
Starts with 14853.
Right, it's again 515.
14853.
It's 14853.
14853. That begins paragraph 15.
And so I want paragraph 15.3.
15.3, as I said a moment ago, is 14854.
I'm very sorry. It's been a long day. So this is just how Mrs. Justice Cockrell, as she then was, summarised the authorities. The application notice needs only to set out a succinct summary of the claimant's case to be read in the light of the relevant background known to the parties. It's for the evidence to set out the detail, so the requirement for particularity must not produce a result which unnecessarily makes a mockery of justice. So here, the parties are very well aware of the background, and Mr. Britton is too. And so one looks at the particulars with that in mind. That anyway is the approach. So there's nothing new in the amended particulars that wasn't in the original application. If one were to read the affidavit of Ms. Jabala along with the original notice. I'll come to the particulars in a moment. It has to be borne in mind that they've had these since the 30th of April, and we haven't had any objections since. Mr. Britton may have some objections, I suppose, but we'll wait and hear what he has to say. But if we take a look at the draft amended notice itself, that's at page 1282. Or is it? Where's the one with the deletions? I'm reminded by Manana Junior that maybe I should take Your Excellency and Mr. Britton to the latest version, which has those little deletions in it. And that's to be seen at 14922. Okay, up and down. Things.
Yeah.
So the amendments being in red, and we start off then with the orders being recited. That will stay as the same. It's not new, is it? We need to see the one as it's changed from the. Sorry, can we go? Yes, because that's the one that's got the red differences in it.
This is the differences.
Is it?
The amendments are in the Schedule A, so further down the document.
Oh, is that the original?
Yes.
It is. Okay, sorry. So all the.
This is the one.
Sorry, I beg your pardon. So paragraph 2 then sets out what the information is that we asked for before.
Well, all of this part is original, isn't it?
Yes. So one sees there, these are the 7 questions that were details of onward dealings, identities of the UBOs, current value location details of all the sums, where they've gone to, who are now the ultimate beneficiaries, then the current value location of proceeds, etc., identity of individuals. So the meaning, and G, setting out what the order means, is unchanged, and that's detailed enough. Penal notice, and the details of service in 4, and then the following orders, paragraph 5, where Your Excellency made the order in October, which spelled out in A that the onward flow of monies had to be explained, and also if unable to do so, then to explain why in C, and then although we're not relying, I think, on D and E in our committal application, there's further provisions there which don't really trouble us. And there is a duplication, of course, between the second order and the first, because the second order is saying comply with the first order. So one criticism made by my learned friend that they were duplicative is not fair, because in fact the 2 orders do overlap. Then 6 and 7 again are setting out the failures to comply as regards and inconsistencies, and Schedule B identify certain transfers and assets, and there's also then the penal notice in 8, and then there's again setting out from A to G what the orders said that needed to be produced, and 10 also about the accounts, 11 and 12 saying what it means. Now, in count 1, the accounts, in fact, I think are the same in their scope. As the ones that we're relying on now, except 2 have been slightly deleted. But if we go down to, and I'm now scrolling down to the bottom of the accounts, so we get to paragraph 34 onwards is talking about the law about the how directors are liable.
This doesn't change. Yes, it doesn't change your name.
No, I'm talking about the changes from the original application.
There's an amended application.
Sorry. Just give me, if I have a moment, please.
Mr. Peto, shall we take it a step at a time for the benefit of Mr. Britton? Can you hear me, Mr. Peto?
Sorry, yes, here it's, I'm sorry, if we look at page 1282, I'm sorry, I got ahead of myself with what we were looking at before. I'm sorry.
Let's actually start at page 1066. This was the original application notice.
Yes, this was the original one.
This was the original, and this is what you are applying to amend.
Yes. And what I was about.
And then at page 1282, this is the application to amend what's at 1066. And what you have taken us to a moment ago is a further iteration of the amendment application.
And that was, yes, that was a mistake. I should have taken, I apologize, I should have taken the court to this document now, which we have at page 1282, because this, in black, so that Mr. Britton knows, in black is what the original application to commit said. What is in red are the changes that we are applying today to make to that original application to commit.
And your
so that
changes,
encapsulates
the substance of your changes are that you wish to add to the original the particulars of contempt.
That is correct, as one sees then in page 1284, paragraph 1. The rest is really, in paragraph 1, is just saying we want to rely on the particulars of contempt as well.
Yeah.
And so in order to see the changes, we then move down to page 1286. 1287, draft particulars of contempt. Yes.
1287 is where the particulars of contempt begin.
Yes, so all this is new.
Yes, so all of this is new. And then this has been further amended by the document that you were taking us to a moment ago in red.
Which I was unhelpfully taking you to out of order.
I just wanted to make sure that we got the chronology for the benefit of Mr. Britton.
Absolutely. So I'm sorry. This is really the substantial document which sets out here where it says draft particulars of contempt. It's all new from there on, and that is what is setting out the detail which we now seek to rely on. So it's quite long. We start off by quoting in paragraph 1 the order of the 28th of February that the court made, the relevant bits, paragraph 1. In paragraph 2, we set out in ordinary English what that means in terms of what has to be done, 2A down to 2G, which are 7 questions. This gets repeated quite a lot. So it's details of onward dealings with regard to the funds. Secondly, who it is, who are the ultimate beneficiaries of those onward dealings. 3, the current value, location, and details of all the sums received in question. D, the identity of the individuals who are the current ultimate beneficiaries of all those sums. And then also in E, the current value, location, and details of all traceable proceeds or profits or substitutes, which means not just where the monies are now, but anything which has been bought with those monies or in some sense acquired by those monies, which may be any other kind of asset. They also need to be disclosed. And also in F, then, the identity of the owners of those assets that might have been bought or otherwise acquired with the original monies. And then G, final question, is documentation which records or relates to the information above. So where it's available, the documents that evidence those matters from A to F. That's the first order. The second order, which is the 28th of February, we set out again the penal notice and also set out that in purported compliance, then we say what Mr. Britton did in purported compliance to the paragraphs of the February order. We did not accepting that it's proper compliance. We mentioned the affidavits that he served together with the exhibits. It's the first and the second affidavit, and further information provided. In paragraph 5, we set out the further orders the court made, which are in italics there so far as relevant. And paragraph 6, although we're not, it isn't relevant for today, actually, I'm setting out a list of inconsistencies, so we're not dealing with that. Schedule B identified certain transfers in excess of £100,000 from the first respondent's bank account, for which payment records will be provided. And the second order also has that penal notice. And then in paragraph 9, we again set out in ordinary English what it means, what those orders mean that Mr. Britton had to provide. And it's starts off by saying all of the information which is in the first order, because that was repeated. Then details the complete onward flow of monies and traceable proceeds in respect of the DMCC payments. And that was an order made in order to make clear that the explanation had to be a complete onward flow, showing every stage of what had happened to the money since it landed in DMCC onwards. C, the documents showing every stage in the onward flow of the proceeds to their current locations and also their traceable proceeds. So that means documents showing what happened to the monies, and if they were used to acquire any other assets, documents showing that, and also showing where such monies or the traceable assets are now. D, saying that if the respondents can't give that information, to say why they can't do it, and to say to the best of their knowledge who the most recent owner was of such assets. And E and F, those are obligations which we aren't complaining about breaches of today, so we don't have trouble with that. In paragraph G, Mr. Britton saying, what assets did you actually get personally from those payments or from property which represents those payments? And paragraph 10, we also then say that the order of 17th of October meant that DMCC had to provide monthly or other periodic statements for all the accounts with FTX and IG that have at any time held assets in the name of or under the control of the first respondent, Mr. Britton, and they're required to be produced for the whole period in question, stated there. And then on the 21st of November, Mr. Britton submitted a sixth affidavit, again in purported compliance with that order, together with exhibits, and these are referred to as the order. So that's all the background, which sets out, we would submit in sufficient detail for Mr. Britton to understand the case as to what he was required to do. Then we come to the counts of the failures in question. Count 1, the failure to explain the complete onward flow of the full amount of monies and their traceable proceeds. 13, we state which paragraphs have been breached, and we say that he failed to explain to the best of his ability in his first affidavit and second affidavit, or at all, the onward flow of the monies and traceable proceeds as set out in Schedule A here too from the payment. So a schedule is giving further details, Schedule A to this, and failed to produce adequate supporting documents as well. and that paragraph 14, there's a like complaint about the similar orders in the October order, but again, particulars of the breaches are set out in Schedule A. That's count. That's count one. It may be a good idea at this stage to go to Schedule A, which is what it was referred to there. So if we scroll down towards the end of this document to page 1299, where we detail the payments which are referred to in the particulars I just read out. The fund and the first respondent, it says the payments recorded in the tracing workbook, a document produced by Mr. Britton. It's first the amount of 33 million to Aria Commodity Finance Limited. So we're dealing here with the 33 million which Mr. Britton says were paid to Aria Commodity. And we say that respondents have admitted that that amount was first paid to the fund and to the first respondent, but in breach of the orders, beyond stating that they were first received by the fund and the first respondent, they haven't provided details of the complete onward flows beyond the initial payments to their current location, the identities of the beneficial owners of the funds and their onward flows, current value, etc., of those funds, the identity of the most recent beneficial owner of the funds, or whether there are any traceable proceeds and so forth, and nor have they given the identity of anyone who might be the owners of all traceable proceeds, nor have they given the documentation necessary to record those things. So that's the particulars in relation to that 33 million. We submit that that is perfectly clear enough and falls well within, and even goes beyond maybe what is required by the test which Mrs. Justice Cockrell gave in the Deutsche Bank case. And that enables Mr. Britton to know what he has to meet. Then if we go down to Aria Commodities, the next one, B, the payments recorded in the tracing workbook in the amount of 83.3 million odd made to Commodities and purportedly paid onwards to the Aria Australia. And again, the respondents have admitted in the tracing workbook that those amounts were first paid to Commodities US and purportedly to Aria Australia. But in breach of the orders, apart from disclosing that first step where the monies went, they didn't provide the details. Again, from 1 to 7 are the same or substantially the same as the complaints made in the previous complaint. So I didn't go through those again. With Aria Ukraine, next in C, first and second respondents have admitted that about 20 million was received by Aria Commodities Ukraine. But in breach of the orders, aside from saying that they were received by Aria Ukraine, they didn't give, and again we have the same 7, it might be here, 8 complaints of why they went. They didn't say what happened to the monies, where they went, whether anything was bought with them. And yeah, the additional one, which makes it 8, is there isn't an explanation of who Mr. Oleg Levchenko is. That's in subparagraph 7, and what his relationship is with the respondents, because he was supposed to be a gentleman who was in charge of the Ukrainian company. Then with Aria Bio, in D, again we start off with recording that the respondents have admitted in the tracing workbook that 82.9 million were first paid to those two companies. But in breach of the order, beyond saying that, they haven't provided again the 7 categories of information they should have done. Going down to paragraph E, as regards the Aria Real Asset Income Fund, this is about 51.8 million, which the FTI report, which was the forensic accountants who were commissioned by the respondents, they said that amount went to the Aria Real Fund, and we then record that the 6th affidavit of Mr. Britton contradicts his own expert by saying that these payments are not relevant to or related to the Dmcc payments, or that this entity did not actually ever receive any funds. So 2 alternative explanations. I won't make any submissions about them now. So in breach, we say there's not an explanation about why FTI said that all this money had gone to the real asset come, but why it is now, they say, the respondents say that's wrong. And then the other questions are the same about the identity of that fund and its owner, the relationship between Mr. Holster, who was someone who communicated on behalf of that fund purportedly, and then 4, 5, 6, 7, 8, 9, and 10. Again, the rest of the particulars are the 7 questions, which are the same again. We're not pressing, I think, the redemptions. F is no longer being pressed, neither is G. And as regards IG Limited, the payments recorded in the FTI report and partly recorded in the tracing workbook say that 46 million was paid to IG Limited. The respondents have admitted in that report the amounts, about 46 million, were first paid, but in breach of the orders, they haven't, beyond stating that, said what's happened since. And again, we got the same 7 questions about 7 issues of what they haven't told us. FTX, we go down to I. The payments recorded in that, the FTI report, say that some 30 million were paid to FTX and its related entities. The respondents have admitted that. But in breach of the orders, beyond saying that, they have not provided, again, the 7 categories of information which they should have done. We're going down to J, carbon resilience. The payments in the tracing workbook, Annex 2, to Mr. Britton's affidavit, say that 10 million was paid to carbon resilience. They've admitted that was paid, but beyond that, they haven't said, again, the 7 categories of information they should have done. That completes, therefore, Schedule A. If we go back to the top of the of these particulars and we get to Count 2, which is to be found on
1293. 1293.
I'm grateful. 1293. Here, it's the failure to identify the current whereabouts and ultimate beneficiaries of the DMCC payments and their traceable proceeds. So in 17, we say that in breach of those paragraphs of both orders, the breach was not identifying, to the best of its ability in his first affidavit and second affidavit, the current whereabouts and ultimate beneficiaries of the payments set out in Schedule A and their traceable proceeds, and failed to produce adequate supporting documentation, recording, and relating to such information in the accompanying exhibits, and in breach of the named paragraphs in the order of 17th of October, failed to identify the current whereabouts, ultimate beneficiaries of those payments set out in Schedule A and the traceable proceeds, failed to produce supporting documentation. We've been 19, we've already seen the particulars of those breaches, don't need to go there again. And in the aforementioned affidavits and exhibits, including in the asset list, which was submitted by the respondents, made false statements and failed to particularize sufficiently and accurately the details, including the valuation, the current whereabouts and ultimate beneficiaries of the assets set out in Schedule B. And by reason of the failure to give accurate valuations of the assets set out in Schedule B, the respondents overstated the value of the assets and thereby, in breach of the orders, failed to explain the current whereabouts and ultimate beneficiaries of the full amount of the payments. And further, in breach, they failed to explain fully the complete outward flows of funds to the acquisition of the assets set out in Schedule B, including who owns them, failed to provide documentation. So particulars are set out in the Schedule B. And so if we go down to, again, the end of the document, Schedule B, will see what the assets are related to which those questions relate. And that's at page
1307.
1307, I'm obliged again. So that is what the assets are referred to above. First of all, there's PT Bar Energy. They stated in their list, in their asset list, that the first respondent had an interest in that asset valued at $247 million. But in breach, they failed to explain what the asset was, where it was, and the basis of the valuation, failed to explain adequately the onward flow of funds to the acquisition of the asset and the ultimate beneficial owners, failed to explain how the asset was acquired, if at all, and when and by whom and by who the current owner is, made false statements in the asset list, which is it's an asset that represents traceable proceeds in the amount of $247 million, when in fact the FT FTI make no reference to this in their forensic report. If in fact it's contended it's a genuine asset, made a false statement about it being worth 247 million, and then failed to provide documentation relating to that information. Then there's the Tanzanian mining interests, which were disclosed as an asset. Their asset numbers 450, 451, valued at 225 million and 65 million respectively. But in breach, it would fail to say what the assets were adequately, where they are, and the basis for the valuation. Failed to explain how the funds from the first respondent had led to the acquisition of the assets and who the ultimate beneficial owners are. Failed to explain how they were acquired, and if so, by whom. And if in fact they are genuine assets, made false statements as to their value, and made false statements in Mr. Britton's affidavits that in fact these assets do represent the traceable proceeds, and didn't provide documentation relating to that information. Then C, the shares in carbon resilience. They stated that they had interest in carbon resilience, but in breach of the orders, didn't say what the shares were with adequate particularity, or to say what, if any, interests carbon resilience holds in wind and solar assets and the basis for the valuation. Didn't explain how the onward flow of funds had led to the acquisition or owned them. Failed to, in fact, it's the same questions which out substantially 3 to 7 to 8, as above, as in the previous asset. So that's Schedule B, which explains count 2. If one goes into count 3, which is to be found on page, that's page
1294.
Yes. It's a failure to disclose assets that Mr. Britton received from the payments in breach of those terms of the order. He didn't disclose the assets of details of assets received by him from the payments or the traceable proceeds from the 2 dates there described, and that's proved by the disclosure in Mr. Britton's 6th affidavit, which recalls that he had in fact received about 15 million, and that previously failed to disclose his assets as required under the order, and they don't sufficiently say where they are now. Count 4, which is on the same page, hasn't produced the account statements for the accounts of FTX and IG. The order specified there as being all account statements for FTX that at any time held assets under the control of the respondents between the dates in question, and ditto for IG. And there's been a failure to produce monthly or other periodic statements for the full period, and hasn't produced statements which recorded all the dealings in relation to each account, and only one produced for IG, and only what appears to be ledger statements, but which don't show the activities in the accounts as will be recorded in the statements. And no ledger statement for one of the accounts. In relation to FTX, it's unclear how the respondents produced the documents, which are said to be the account statements. He doesn't explain properly what they are, how he's produced them, for which accounts appears they're produced, and what were the transactions. And they don't constitute adequate account statements. They don't contain the information normally contained, such as funds paid in and out, and the activities involved. And they failed to explain, as required by the orders, complete flow of all the monies after they were paid into FTX and IG to their current locations, with supporting documentations. And the amounts recorded in the FTI report, as paid to IG, as particularised in Schedule A, record transactions in amounts exceeding 70 million, which haven't been explained. And as particularised in Schedule A, the FTI report recorded payments to FTX and to its affiliates, which are over 30 million, have also not been adequately explained, including by the provision of supporting documentation. And in addition to those obligations, they should have provided monthly or other periodic statements of account which record all the dealings in relation to each account, show what happened to the funds and their current status. They didn't do it. That's count 4. And count 5, the failure to produce all payment records identifying individual or corporate recipients of outward transfers from the bank accounts, and they failed to provide all of them. They were required to provide all payment records for outward transfers in excess of 100,000 from the bank accounts, as listed in Schedule B, so that's been particularised already, paragraph 32, haven't provided payment records for 48 of the payments, totaling some 80.6 million, as defined and set out by Annex to Ms. Jabala's second affidavit. And Mr. Britton stated in his sixth affidavit that 41 of these payments advised did not exist because they were internal transfers, and said that the receipts of the payments were identified in corresponding bank statements. But in relation to that explanation, his non-compliance, there are in fact 12 of the 48 payments where the beneficiary has not been identified at all, and for the payments claimed to be internal transfers, Mr. Britton hasn't produced the payment records identifying the individual or corporate recipient of the next onward transfer, which he should have done. As set out in Annex 1, 35 of the remaining 36 payments were initially made to other Aria entities, including 23 amounting to 17 odd million, but no information or documentation is provided as to the onward dealings with following these alleged internal transfers. We haven't been able to locate a corresponding bank statement with respect to 32 of the payments. Finally, count 6, which is dealing with assets which are the traceable proceeds of the payments by entry into conditional sale and purchase agreement for the shares in Carbon Resilience. And this is an allegation of breach of the freezing order not to allow dealing with assets which are the traceable proceeds by procuring or aiding or abetting the entry into a conditional sale and purchase agreement for the sale of the shares in Carbon through, the particulars are given through which companies without any prior notice of approval, and willfully taking reasonable steps to ensure obedience to the terms of the orders by preventing that sale. And then after that, we are dealing with the liability under the law. So our submission is that those particulars, in any view, make it quite clear what the allegations are in considerable detail. We no doubt what they mean. They're all encapsulated in the tone of the original orders, that these have been known to the other side since the 30th of April. Of course, it's open to the defence to deny that there's any guilt there at all, to deny that the orders mean what we say they mean. All that is argument. That's not a capacity for a strikeout or for opposing the application, which is, of course, the same test, really. Is there any reason why these should not be allowed now and the timetable is adhered to trial? In our submission, no. And justice requires that the amendment should be allowed.
Thank you very much. Mr. Britton, let me explain to you the ground rules. So Mr. Pito is correct when he says that one of the tests for whether or not an amendment should be allowed is if it's essentially hopeless. The court will not allow an amendment to any claim if it's not going to, at the end of the day, stand up. Another question is timing and whether it can be dealt with, whether it's too late. Those are the two principal, I think, grounds for objecting to amendments generally. If I can give you the benefit of my view so far, and subject to anything you say, in fact, this amendment is somewhat to your benefit, because the original committal notice, which the claimants say was of itself adequate and did not need amendment, was in much wider terms. And you may be aware that I expressed some reservations about that, because in a committal, it's essential that the allegations that are made are precise, and the court will look at whether those allegations have been proved to the appropriate standard. So the fact that this amendment makes more precise and distinct allegations means that you're not facing wider allegations which, to use a colloquial term, would give a great deal of wriggle room to the applicants. They are tied down to specific and particularized allegations against you. So On one view, certainly it can be said that there is a benefit to you in not opposing these amendments, but it's up to you. Is there anything that then you would like to say in opposition to the application? You're on mute, I'm afraid.
My apologies. Thank you, you're kind. Well, Your Excellency, I just want to make it clear in the first, this is all maiden territory for me, and job number one is to ensure my voice doesn't break. The second is that Horizons have been absolutely scrupulous about sort of maintaining this scope boundary hygiene, if you followed. So I am, you'll have to bear with me if there are any procedural shortcomings or if I'm not responding appropriately. So maybe perhaps just a couple of points from my perspective. The first, I think I need to stand by and rely on the position in the holding skeleton of the 21st of July, namely that, my right to be heard in opposition to this application is reserved. I don't feel I'm able to argue this without legal advice, in short. Secondly, I imagine that given the foregoing and what we've heard this morning, the court has just adjourned the committal application to the 31st of August, so that the respondents can be represented. This application seems to settle those charges, and so I would just ask respectfully that it travels with it, and it can be dealt with when I'm represented. However, finally, should the court be minded to deal with this application today, I just simply ask for the final version to be provided as permitted and proper time to respond to it with legal advice. So that's all I can offer at this point. Forgive me if
that's fine. Look,
yeah.
I am going to. I don't need to call upon Mr. Peter. I am going to grant the application to amend. It's going to be formally served immediately. Horizons have been, as far as I'm concerned, absolutely cleared to represent you on the 31st of August. And we have a timetable for responding to these particulars that you will have heard I discussed with Mr. Yates on your behalf. So what this means is we have some certainty, and we have removed the two matters that Mr. Yates said were the blockages to actually getting round to a hearing, namely the fact that you were not represented and that the particulars against you were unclear. They're now clear because I have given permission to the amendment, and you can be represented by Horizons because I have given my interpretation of the order of the 30th of June, which I have said has been satisfied by the information they've given. So we've cleared the decks to enable us to have a properly constituted hearing on the 31st of August. Okay?
Thank you, Your Excellency.
Thank you. In relation to any costs that's attributable to this, these will also be reserved, as with the costs in relation to the adjournment application. I think that's right, isn't it, Mr. Peter?
Yes. The two things seem to go together. As regards the final documents in relation to which Your Excellency is giving a leave to amend, of course it is the third one which I took you to out of order, which is the one that's got the deletion of two allegations.
That of course, that's fully understood.
Yeah, fine.
Okay, and your solicitors can, well, obviously it's already in circulation,
Yes.
but it can be formally served immediately.
Obliged, yes.
So
I think that deals.
That does deal with the amendment application. You wanted to have until tomorrow morning to deal with the remedy application.
It's
now
maybe I could,
5 o'clock, in fact, Dubai time, so it will be tomorrow morning in any event.
Okay, yes. Well, thank you for your patience in hearing this a little late.
Not at all.
So
that's fine. Look, since all that's left is that application, I don't see any need to have both you and Mr. Britton get online at an ungodly hour. I think it was a 7 o'clock start for both of you this morning.
Yes.
But equally, I don't want to have a luncheon adjournment in the middle of the application. So if I were to say 2 o'clock Dubai time, 11 o'clock English time, would that be okay with both of you?
That would be wonderful.
Thank you.
Okay.
Yes, that would be, thank you so much.
Much obliged. Much obliged.
Okay, well, in which case then we'll deal with the remedy application at 2 o'clock Dubai, 11 o'clock UK.
Thank you very much, Your Excellency. So until tomorrow.
Yes, thank you very much indeed.
Thank you, Your Excellency. Thank you all.